at this point, like, we verbally agreed, I should have contacts from UM, their PT for athletics.
What's your obligation?
2 point, click at the top corner, 8 hours a week.
Yeah.
So,
I want to be able to see everybody.
I don't know. I'm judging, watching.
You just make sure that, I can't tell if they're in the waiting, but they are not. I see that we have members of the public. I just want to make sure they're not in the waiting. Before you start. Okay, there.
Without objection, we will use a 3-minute time limit for each speaker, and the secretary treasurer will keep the timer. Good? With assistance from staff member Angela Green. Thank you, Angela. So let's start with the Pledge of Allegiance. Lee, I'm not sure what the flag.
I believe Tiger Stadium. That way? Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
No day you lead us.
Yes, please. Dear Lord, please shine upon us your everlasting light and help guide us as we come from parts of the state and all parts of our profession and all walks of life in order to better serve the public and to protect the public of Louisiana. Amen.
Amen.
Okay, I'm gonna get the secretary treasurer to make a roll call, please.
Okay. All right, Mr. Ben Gaines.
Here.
Matthew Williams. Absent. Claude Tremblay.
Here.
Michael Hildebrand.
Here.
Lee Riley.
Here.
Adam York.
Here.
O'Day Laverne. Here. Danny Louis.
Here.
Mr. Chairman, you have a quorum.
Thank you, Dick. The proposed agenda was distributed. Are there any amendments to the agenda as distributed? If there's no objections, the agenda is adopted. We'll now open the floor for any public comment. Members of the public wishing to comment should be recognized before addressing the board. And if you please state your name for the record. We'll move on. The next item is approval of the June 2026 meeting minutes. Are there any corrections for the minutes? No further corrections. The minutes are approved. We will now receive the secretary treasurer report. O'Day, you want
Okay, yes.
to speak?
The report is printed in your packet and has been disseminated in your meeting packet. The basic highlights of the budget are right now, today, we're going to look at May because June is being closed out to wrap up the year and is in the CPA's hands for making the final year-end adjustments. So at our next meeting, we'll be able to review the year as a whole. In our May budget, we were budgeted to lose $68,000. We lost only $61,000 for the month. Okay. Year to date, we can compare year to date to this time last year and also a year to date budget. So here we have year to date budgeted. So year to date budgeted, we were budgeted to be in excess deficit spending of $118,000. Is our year to date budget. Our annual budget is $456, and we're currently at 60,000 plus to the positive. All right. And if we then look at the next at the balance sheet, and our balance sheet compared this month, year to date as compared to this time last year, our assets and liability are increased by $500,000. So our total net assets are up approximately $500,000. Any questions? That concludes my report, Mr. Chairman.
Thank you, O'Day. We will now hear the executive director's report. Charlotte, may I proceed?
Okay, as of the 13th of August, we have 101 open complaints. However, 70 of those are related to the same issue. We have a breakdown of those. 4 are fraud, billing, or documentation. 2 are malpractice claims. We have 15 criminal cases, 5 practice-related issues, and then unprofessional conduct. Those are the 70 plus there's 5 more. On unlicensed individuals, people who aren't licensed by our board, we have 2 complaints. Since our last board meeting in June, we received 13 complaints. We had 1 informal conference, we have 1 appeal, and then we have 4 proposed consent orders issued out to respondents. We've closed 5 cases, all with dismissal. We have 11 individuals in our recovering physical therapy program. 2 are in the confidential route. We had licensed 118 people between the last board meeting and August 11th. 73 of those are PTs, 45 are PTAs. And then for our compact, we currently have 54 compact privilege holders. 41 are initial holders and 13 were renewals. That concludes my report, Mr. Chairman.
Thank you. Are there any questions or discussions regarding this?
Do we have a net gain on the licensure or net loss?
I think we have a loss versus the last number, so. Then we have, how many people we had leave last time? I know it's not information you have right in front of you.
Okay.
But we had a bunch that were leaving profession in general when y'all did that study.
Yes,
So-
so
It was a high number though.
yes, so there was a reduction in the percentage of those who, or there was an increase of percentage who did not renew. But we do have a net gain in licensees, even with the compact, because we were kind of waiting to see, once the compact was started, how our licensing numbers would look. I can bring in more detailed information at the next board meeting about year to year, how we're gaining in licensees, if you'd like the actual licensee population.
Awesome, thank you.
You're welcome.
Is there any more questions? Okay, thank you. Thanks, Charlotte. Next, we're going to unfinished business. This will be the rules revision, proposed changes from Rule 103 to 123.
Okay.
We'll ask Charlotte to walk the board through the proposed changes for us.
Yes. And before Charlotte goes through this, what I'd like to do on behalf of the Practice Act Committee that's been working on the rules revision now for about 3 years. We completed what we thought we had, presented it to the board. It's been out there for months now. We've given it to legal. Legal's come back and said, yeah, 90% of it is exactly what y'all said. Here's a few things that maybe need further discussion with the board. So those 4 items that y'all all had in the legal report on the rules, we then had a Practice Act Committee and brought on 2 subject matter experts. We invited Paul Hildreth. He was unable to attend that day. We brought in Christina Fauché, all right? And we had some other members of the public that attended the meeting, Katie Britton and Amanda Brewer. Had a great conversation. But the history of where we come from is this. First blush through the rules. We were triggered by the concept of Idaho doing a 0 rule revision. They went through their rules and said, what can we just get rid of that we don't need at all and have as few rules, minimum rules as possible? At the same time, we were looking at that as a point of interest. We had a change in administration in Louisiana government, and the governor says, decrease rules, right? Decrease boards if we can. Let's make sure we're functioning and let's make sure we're doing the right thing. And today, right thing is decrease regulation, decrease administrative burden, decrease obstacles and barriers to practice. So we can increase the workforce and then make the services more accessible and affordable to the public. Having said that, first round through the rules, we said, all right, what's absolutely duplicative? All right, if you go to the first page of the law, it says the board's domiciled in Lafayette. You go to the first page of the rule, it says the board's domiciled in Lafayette. Okay, we don't need that. It's duplicate and it's redundant. So first pass that's what we did. Second pass, we read the law and said, see rules. Okay, to be explained in rules. So that means the rules necessary. So then we went to see that rule and said, okay, is it necessary and is it modern and up to date? All right, so we looked at that to make sure that we had those rules. And then we went and said, all right, what's just burdensome and unclear and what can we do? And let's either strike or try to clarify. And then it went back to the attorneys and to Charlotte to say, okay, we think these rules are just way too much. Let's get rid of some of this stuff and clean it up and thin it out. But don't let us take the teeth out of enforcement by diminishing a rule or taking a rule out that you needed. All right, so that was Charlotte's review. Then after Charlotte's review, she then turned it over to legal. And then legal looked at it and said, okay, let's make sure we're not, and Elise could tell us what she looked at, but let's make sure it's not in conflict in the law. Let's make sure it's okay to get rid of it, that you're still covered. And still also looking at, we need the legal teeth to do what it is we're supposed to do to enforce the Practice Act. Okay, so that's where we are. Now, finally, after about a year of sitting around, we're getting traction. People are starting to pay attention now, okay? And as we go through this process of getting ready to put in the state register and go through the Administrative Procedures Act, we're going to try to have as many stakeholder meetings, town hall meetings, public meetings as we possibly can. So then when it's time to publish and we go in front of the Legislative Oversight Committee, if we need to, if that happens, we've done everything we needed to do ahead of time, as opposed to that being part of the process. So we're going to implement that process ahead of time. And I think y'all have seen Charlotte's pretty aggressive schedule of what's going to happen for the other two segments so we're going to break this up into three chunks. Today, we're going to get through definitions. Then we're going to break the other two into chunks. And then we're going to recognize that since we started the project and today, the emphasis on what boards should do and how boards act is changing. And I think it's going to open up some discussion on supervision. It's going to open up discussions on continuing education. It's going to open up discussions on healthy practice, because we now have seen why people violate. So if our number one job is to protect the public, make sure they're safe, then what is it in these rules that make the public safer? And if it doesn't, get rid of it. Okay, it's just gonna be that simple. So, yes, sir.
I think to piggyback off of what Odae's saying, that, I understand that the concept of deregulation and for people to understand that it's not just like haphazardly happening. The stage process is eliminate the redundancy and all that kind of stuff. But I was talking about like deregulation. There's things happening on the backside that's going into that, looking at other boards and neighboring states that are also operating in the same capacity as us, but much less regulation in a sense. And so how's that working for them? How is their investigation process going in relation to that? Is there any more incidents that are happening because of that lack of regulation compared to what we have? And so, and other boards in our state, you have the OT board, if you read their Practice Act, it's way different than ours. It's very broad, right? And so what does that look like on a regulatory standpoint for them? What are they encountering that, that we're saving people from with the amount of regulation that we have? And so that all thought process goes into all of it. It's not just, you know, haphazard, let's cut this out, let's cut this out. We think we'll be able to get more people to work by doing this, we'd be able to get this. We're losing people to Texas, to Mississippi, to other states that have less regulation. What are they doing that we're not doing? Or what are we doing that they're not doing? And is there any type of negative effect in there? It's not just, we're gonna cut the regulation to make it easier for people to practice here, and people want to come here and make it easier for business to operate. That's not it. It's, what are they doing? You know, the stuff that they're doing that we're not doing, in a sense of us having more regulation than them. Is there any, we're still doing the research and looking into it to make sure that there's not gonna be a negative effect on that deregulation. You know, it's not just haphazardly happening. Those things are being reviewed and looked through when those decisions are made.
And Charlotte, to that point, what is our percentage of licensees that get in trouble?
So, yeah, it's what's reported to us
Complaints,
is,
yeah.
less
Complaints.
than 1% of the licensees
Less than
get
1%.
reported, and then, you know, not all of them are found in violation.
Right. So less than 1%. And then recently at Continued Competency Committee, I was accepted to participate in the FSBPT's Continued Competency Committee. Went to that meeting this summer, was really pumped up to find out what continued competency is. Conversation was, you know, if you go to your CEU and you have a pulse, that's continued competency. Okay. What they're looking more at now is healthy practice, because they're recognizing the same thing that we're discussing, is that there's 3 types of people that get in trouble, and less than 1% get in trouble. And it's people who have drug and alcohol issues. It's people whose life, and I'll just say this once and then I'll change my word, but it's people whose life is a shit show. Okay. And people that are psychopaths and sociopaths. Okay. We can't cure them. We just got to find them. We all know who they are. All right. Then the people whose life is a sideshow, we need to help them. And that's what this healthy practice tool is about. Okay. It's helping people recognize when their life is a mess, because that's when they tend to break the rules. You know, they just got a divorce, they lost their house, somebody died, there's a disease in their family, whatever's happening, it overwhelms you, all right? And now we're hearing too much debt, not enough salary, okay? All of the stress, all the burnout. Help these folks recognize their problem, give them a tool, and will keep them from falling in that trap. Other than that, nobody's proven that anything else we're doing is making anybody safer. So, you know, having said that, let's recognize that we have to regulate for the less than 1% who choose to violate the rules.
Yeah, and I think we're doing, you know, an outstanding job on trying to help that percent, that 1/3 of the 1% of the category that you were describing, of people with the, you know, strain on their lives, right? Like, you know, just because things are squeezed now as a profession, you know, we understand that, you know, everything's squeezed, time squeezed, people have everyday life. And so I think that, like, the conference that we're doing, that educates people on what people are having issues with, how to handle different things, and giving them information on the front end versus being punitive on the back end you know, it's going to serve that 1/3, you know, and I think that's great of what we're doing with that.
I look at the rule change in 2 different ways. One is common sense. What leads most people to transgress? Lack of education would be 1 on rules and regulations. Number 2 would be socioeconomic and psycho-emotional issues that may lead them to. The second way that I look at it is a little bit more legalistic. I think in reading the rules, and because we're in the change of those rules, I think we need to approach it very succinctly in what is our mandate and what are the boundaries of what we have. I think in certain areas, there's an overreach and there's common sense that doesn't exist per se. I understand the conceptual aspect of, but I think as a licensing board, we have defined limitations, and I think in certain areas, those limitations have been kind of expanded without staying within what we have from, you know, what we perceive as common sense, but not proven by science. And we'll leave it at that. But as we move forward, I think we need to be critical, the same as the Practice Act Committee, looking at this critically and making sure that there's no redundancy, that terms are clearly defined, but also that the board is also evaluated to be clearly defined in our role in the protection of the public without regulating us to death and making it more and more complicated. But I think in both of those, subject matter, I think the one that reaches me a lot deeper is an ounce of prevention versus a pound of cure. So coming in and be punitive, and I don't think that it does work, scares people, and leads them to be in a position of saying, well, I didn't really know that, because they failed to ask questions, or there's no real incentive of reading this very dry document because they think they're doing it right.
I think when you set people up for success, the violators will always violate.
Yeah.
Yeah.
Those people will do, and the people who fall into some type of cycle or whatever that may be, the education that we're providing, I think it is useful for them to kind of bring them back home and to steer them right. I think violators will always violate. People will always show themselves. So,
But there's two main categories that Bo Dave pointed out. One are going to be the sociopath and psychopaths. They need to be found and gone. And if we could do preventatively, through scientific surveys or, things that would lead us to help weed those out, that would be awesome. The second one, I think, as part of our mandate to have a healthier practicing public, is to have resources available that would be done through the renewal process, where they have psychological evaluation tools that tells them at the end, hey, you're doing great, or hey, maybe you should reach out to, almost like the casino sending, do you have a gambling problem kind of situation. We're not going to shove it down your throat up until there's a transgression, because as we've discussed many times, we are innocent until proven guilty. So we don't want to come in and guilt people and then say you have to go through all of this to be proven innocent. But I think that having some form of evaluation tools that are part of what we have as a requirement for our licensees would help them evaluate a little bit more critically.
Yeah. Mr. Chairman, to Claude's point, and then we need to move on with this, is the Healthy Practice Tool is what the Continuing Competence Committee worked on all weekend. And, we've rolled it out here. We're the #1 leading state that has used the Healthy Practice Tool, right? Puerto Rico is us, but we think that they're doing it in school with their kids, okay? But, we were leading the pack and using the tool. And we were all asked to do a segment. And I said, I blew it off. I wasn't interested in doing that. I just playing games and stuff. I'm sorry. I don't believe in burnout, but, I just get up and go. But before I went, I thought, well, I probably ought to take one of these so I don't look like an idiot when I get to this meeting here. And so I took one, and it took me about 10 minutes. And I said, oh, okay. I answered the questions honestly. I took another one. Well, okay. I was in and out in 10 minutes. Interesting questions. When we got to the meeting, we said, let's do this. Everybody take a segment. So there were 10 of us. Everybody took a segment. Go home tonight and answer it worst case scenario, don't say that your life is good. Everything's bad. It took 2.5 hours to go through a segment. Okay, because for every question you ask, there's an algorithm, all right, getting pretty good, and they've not even used AI yet to get to this algorithm because we were still searching articles by hand in the room. But if you answer a 4 out of 10, it sends you down this algorithm of sources to go to and look and do some self-reflection. If you scored really, really low, then there's 10 articles or 10 references and 10 things that you could do. And really was helpful, okay? And I said, this is really a good tool, okay? And then what we did is we went through that and trying to make all the references, not necessarily physical therapy in particular, but multi-professional, because HHRI is the one that owns the tool, and they're trying to do it in multi-professional because it's really an amazing tool. So we need ethics, we need jurisprudence, we need to give people who are troubled an opportunity to get some information and get some help and get some guidance and help work towards that healthy practice. I think that tool is there. I would encourage us now, after hearing this, to all go home and take a section, okay, and take a look at it, and then answer it like you honestly, and then answer it like your life's a sideshow, and see the tools that are there.
I tell you,
Pretty impressive.
I went through it for my continuing education. I did all of them, all of the
Yep.
hubs. I went through all of them, and the resources that are associated with it are really good. Yeah, I mean, there's tons of resources that give you articles that, how to work through this, how to better this, how to better handle this, how to better manage this. It's just tons of each one. So you answer, and then you could easily click through them, but to get the CEUs, you have to be able to go through them all and go through each step. But if you take the time to read the stuff they have really, really good information in all of them.
So, with that, all right, Charlotte, could you take us
Yeah.
through?
Real quick, I'm gonna, since you mentioned FFPPT, I know we got the award, right? For 2026 Regulatory Excellence Award.
Yes,
Which
yes.
is pretty good, which is
Yes.
awesome. And that's Louisiana is stepping up and doing great things. So congratulations to us.
Yeah, and just to piggyback on that, I want to thank you for your service on the national committee to bring information back. O'Day, because that's extra volunteer time you have to serve and a great perspective you're bringing to the room. And Adam, thanks for your time to do that tool, because I think if we're giving credit to the licensees on these tools, it's really useful to be able to go through them and understand them.
It's very extensive. And I think there's tons of articles in there. It's not just like a blank one page that you go through. It's tons of.
I think like 97% of your PTs are great people. I mean, because we try to help people. That's our role, helping people, right? But I do think PTs and anybody, you just don't know what's coming in your future, what's ahead. You might have financial situations that might put you in a bad position where you're like, man, I got to see more patients or something. Or you might have other issues. You don't know what's going to pop up. So you need a tool that can predict the future that, well, hey, what happens in these scenarios that can help me out in case I happen to go down this road or start down the road I don't know about.
Listen,
Because you just don't know.
life is still life.
Life gets you.
That's right. Life is
You're
still life for
busy.
everybody.
As reimbursement goes down and as it's hard to find PTs, workforce data shows you less PTs, puts a lot of stress on the PT. And they don't even know that stress on them until it's too late sometimes. So I think that workforce, that is great. I don't know how you start implement that with our licensees, but it sounds like a great thing to work towards.
So, okay, so the rule packet was, attached to the agenda. Today, as O'Day mentioned, we are trying to make this more digestible. And so we said, okay, let's go through 103 to 123. There's commentary as well. Everyone had an opportunity to review this ahead of time. The goal today would be for you guys to let us know if there's anything that's concerning, anything that you want to discuss. And then what we'd like to leave the board meeting today in is having enough edits or whatever needs to go into this portion of the rule that we can post it on our website and email it out to the licensees to have what O'Day mentioned, the virtual town hall meetings, and get more public comment. So right now we are in a receiving public comment phase. And then we'll have a practice act meeting about all those comments, consider them, and then bring if any recommended changes after the changes y'all make today, we would bring those to the next board meeting and we'd start on the next chunk. Okay, so it's up to the pleasure of the board if you want me to go through them rule by rule, or if y'all want to bring up anything that you see as problematic or concerning, or you want to
I
discuss.
say go rule by rule.
Rule by rule? Okay, great. So, rule 103, the domicile of the board is being proposed to be red line. It's already addressed in the Practice Act. And so, are there any concerns with scratching that from the rule? It just simply references the law. Okay, rule 105, the meetings language that currently exists in rule is being proposed to be scratched. And instead, we're changing the title to electronic meetings requirements, and we're adding language in there about electronic meetings.
Mr. Chairman, there was a comment that was posted by a member of the public. Katie Britton posted some comments for the board to consider. And she had a question regarding whether the current language that is being proposed for Rule 105 meets all the requirements of the Louisiana opens meeting law. And scratching all the rest of this, or any of these components that are required by that law, or just keeping what the language that we have. Can we get an opinion on that?
So I'm not sure I fully understand her question, but the open meetings law already exists. It doesn't have to be repeated in the rules. There's no mandate within that statute requiring the board to adopt or keep a rule specifically referencing the open meetings law.
Good, thank you.
Do you think that addresses her question?
I think there was a specific concern also about public comments being scratched from our rule, and what would be required by open meetings law in terms of public comment to make sure that we don't lose the ability to have public comment.
Sure, we wouldn't lose, the rules cannot affect the right of the public to provide public comment. That's already incorporated into both the open meetings law and the Constitution.
Thank you.
So it's not need, we don't need to restate it in our.
Correct. And if we did, and if there was a conflict, the statute would
Yeah.
preempt. Mhm.
Question. Amanda Brewer, member of the public. Can you clarify?
Point of order is the public can make comments. This is not a question and answer session for the public, according to Robert's rules. So if you have a comment, I would love to hear your comments. I absolutely do.
Rephrase.
All
I do
right, thank
not
you.
have a
That's all you
question.
have to do is rephrase.
Have a comment. Okay, my comment is it is confusing currently whether the public has an ability to speak at an open meeting when it's conducted electronically. Currently.
Okay.
And I'm confused on if this is intended to affect that or not.
So again, the board's just, I think it's helpful to clarify here. The board's rules cannot change or amend the open meetings law, which incorporates the ability for the public to provide public comment. So the board's actually not mandated to incorporate much of what's here for electronic meetings. That's already provided statutorily,
And
but it does provide some clarification.
to address the comment, is that comment is prohibited from a distance if you're not at the meeting in person.
That's what I understand today
Yes.
in previous meetings to function, but not all previous meetings. And so my comment is that I'm confused because a few minutes ago it was said that this is under electronic meeting requirements, and it was mentioned so the public can participate in the open meeting.
So my
But
question,
it seems,
my question to you, based on what I'm understanding of the comment, is open meeting statutes apply to all forms of comments, correct? Electronic, in-person, commentaries via emails. So whatever we have in here does not trump any of the general public from making comments.
That's correct. And to
covered.
Ben's point, it cannot.
Okay, so the limitation on the open meetings law is that if we have an electronic meeting, that we can only have 2/3 of our meetings that way. For that limitation, you can broadcast your meeting and it doesn't count against your 2/3 meeting. And I'm looking at you, Elise, because I'm making sure that this is the way I read it and this is the way I've understood it, to be. So therefore, if we can only have 2/3 of our meetings electronically, and, there's been years where we've had a hurricane and there's no way for the board members to get here, or, one year somebody got COVID and we were like, and that wasn't even during like the height of COVID, but we were like, let's not risk it. Let's just do it remotely. So we try to reserve whenever we can't get a quorum together to have those electronic meetings. But and that's whenever the public would not be able to comment, is if everyone's here and we're having a board meeting, but we're broadcasting it. That is for the public to be able to view the meeting.
Right, that's not an electronic.
That's
meeting
not an electronic.
Within the meeting,
That's right.
meaning of the electronic meetings law. There's a distinction. We are
Mhm.
live broadcasting today by way of example, but this is not an electronic meeting that we are conducting here today.
Yes, because we have a limitation of 2/3 meetings. So if we allow the public to participate, even if all the board members are here, if we allow the public to participate remotely, then that counts against our 2/3 meeting. So therefore, we can't allow participation unless it's going to count against our number of board meetings allowed for the year that can be that way.
Okay, so let me ask you this, if we need to make clarification, should that point not be clarified in this? Or do we just go by the fact that it's already written in statute? So if it's already written in statute, why do we even have section 105?
So 42:17.2.E2 says that boards shall promulgate a rule about electronic meetings. So that's why, because it says shall. Sometimes the law says that we have to.
It would be helpful to know where it's required to have 2/3, but there's a limit, of 2/3 of the meetings to be conducted electronically. And for consideration, there was a bill that passed, well, I think it got all the way to the very end. I can't remember what house, if Senator sent to House, but it would have required, so I would expect it to come up again. Making sure that we don't have anything that would conflict with that at that. But it would have required all state bodies, government entities, town hall meetings, those sorts of everything, every state body to offer these participation via broadcast or the online attendance. So knowing that that almost made it through, and I believe it ran out of time, that's likely going to be coming in the future. And so it would be helpful to know, where is it that your electronic meetings are limited? Is that something within the board's control, or is that an external?
Yeah, I'll refer you, if you've received a copy of what we're reviewing today. If you look in the commentary, it gives you the statutory citation and it's there.
And another public comment, if the board shall create electronic meeting requirements, it may be confusing to only pick parts of the other part of the law. What if the board would consider just having that it would follow the already established, or I'm sorry, you're required to establish rules. That's correct. So in other areas, I have seen that our rules may say that it follows another area of law or rules. So would that be less confusing? You know, put the whole thing in, or say it's refer it to where it's going to jump at the meetings, or it's confusing that it doesn't have all of it.
Okay. I think we hear your comment.
Thank you.
Yeah.
Yeah.
Thank you.
Thank you, man. Thank you, Matt.
Got it?
Yeah, I'm just making a note.
Going
All right.
on 107.
Disability accommodations, this is rule 107. It used to be officers. We are proposing to strike the officers language and to add disability accommodations, which is required as well in another law. And it's referenced in the commentary. This language, that we have a coordinator of disabilities at the state, and the state office provided this language as, template language. We can modify it however we'd like, but we just put the template language in there because it says that we shall put language in there, and this would be compliant with what the coordinator of the state would consider is necessary.
Chairman, I have only one comment about this rule, and it relates to provision D. The participation via electronic means shall count for purposes of establishing quorum in voting. My understanding is that it's making reference to board members. And that language is already included in Rule 105B. So my question is whether that language is redundant and needs to be included in Rule 107.
I can just point out one thing.
Yeah.
There are separate statutes for electronic meetings in order to accommodate a disability, and then electronic meetings generally.
Right.
There are two different statutes, so they do have different requirements. And by way of example, with regard to the limitation on the number of meetings that
Correct.
can be conducted electronically, there's no limitation when it's for a disability accommodation. So there are two different areas of law to be evaluated. To your question.
So if it's-
So they're not separate.
So
They're not what?
they're not
The
necessarily,
language is not redundant.
No.
They're distinct.
They're two different,
They're
two
two
different
statutes.
subjects.
they're adopted pursuant to two different sections of the law.
Yeah.
Thank you.
But if it's already in statute, do we need to have it in the rule?
So as Charlotte raised earlier, the statute does require, it compels the board to adopt rules in order to enforce that statute.
Yeah.
So the specific language is not set forth in the statute. We're not told exactly what language the board needs to adopt, but the board is directed to adopt rules to allow for electronic meetings, both for purposes of disability accommodation and for other reasons.
Thank you.
Thank you, Lisa.
Okay, rule 109. Well, what my understanding is D is going to, we're comfortable with D remaining for the public to consider. Okay. 109 committees is recommended to be completely stricken from the rule. Compensation, rule 111 is recommended to be stricken from the rule. The next one is 117, executive director. It's recommended to be stricken from the rule.
Page 3, 113.
117.
Okay.
So, and these reference the Practice Act. Okay, declaratory statement. At our open meeting in December, a comment was provided from the public, from a representative of the professional association, and it was recommended that we take number 3 under A and strike that declaratory statements shall be made available on the board's website. And the recommendation was that, the board should have discretion as to whether or not they want to put it up there as well as leave it up there for a period of time or take it down because over time things do change. And in the past, declaratory statements were outdated, things like that. So they just said, that would give the board more discretion or flexibility. Any concerns about that?
I do also believe I've seen some comments. It might have been Katie Britton's comments on this section, that she had concerns that the board would have its total discretion whether or not to publish it or print it. All right? But I think historically is exactly what happened, because it said, and shall, it's every declaratory statement that the board has made was up on the website, and they were conflicting, they were contradicting each other. Some of them were 10, 15 years old.
Are those made in response to a request from, say, a licensee or, so
They didn't used to be, they were, and
or we would just take a position on something?
20 years ago, the board would take a position on something and put a white paper out.
Yeah.
Okay, and make it a declaratory statement. And then you have, today, a real declaratory statement should be someone that has to ask a question, they have to be aggrieved, they have to tell you what their grievance is and how they're being harmed, and then we respond to that question, in writing. And if it's I don't know, I'd like to think that the board, if it's something that doesn't impact everybody in the world, just answering a question. Just because you answered a question doesn't make it a declaratory statement.
Yeah, I mean, I guess my experience, I've seen other boards, when they take like what they call them statements of position or whatever, right?
Yeah.
It's a more global issue that's affecting the practice, or say like a new trend in medicine that hasn't been completely accepted, right? And they'll go take a position on use of ketamine or whatever that
Yeah.
LSPME has. And so I think those help, in my opinion, that if to give some guidance, but I'm kind of like with you, if it's just a little one-off questions, there's no point in doing it. To be honest, some of them on the LSPME's website conflict over time because they cross with some of the issues with the Board of Pharmacy has, and so it can get messy, but I like the idea of at least having the latitude to, if we want to post something, right, because we think it's been
Right.
asked a bunch of
Right.
times, put it out there. I mean, but
Chairman, in terms of language, then could we not change 121A3 from shall to may? And so it would state that the declaratory statement of the board in response to the letter shall be in writing and may be made available on the board website.
Yeah, I don't think by scratching it, it doesn't say we can't put it or that we won't put it, but may is,
Shall has more of a mandate.
shall has a mandate, yeah,
Than may.
yes, I don't mind that.
Correct me if I'm
Yeah,
wrong.
no.
But may gives more discretion than shall.
It does. I think for clarity, though, you would also want to add at the board's discretion. So it may be made available on the board's website at the board's discretion.
Thank you. That's good.
Public comment. Amanda Brewer, member of the- I believe, even though some of them may be outdated, we can still learn from them. If you consider how many times has a board attorney brought up an AG opinion? Or how many times have you had to refer back and look at an AG opinion? I know that I have numerous times. There is a reason why those are accessible. And I believe that our board should function in the same manner. And maybe it could be organized on the board's website in a way is posted on there, that you can see if there was a new updated version due to maybe a change of law or something like that. And now there's a new declaratory question and the answers may be different between basically two of the same questions. Maybe the website could refer to that to kind of eliminate that confusion. But I do believe that we learn from it, and it is often, I believe, people asking declaratory statements for the confusing parts that they don't understand after going through the practice act. So my opinion would be that it remains shall, and it should shall still be posted on the website, so that licensees can refer back to that, and have that history, just like attorneys and others refer back to each other.
Thank you.
Thank you. Thank you, man.
Okay, so just for clarity, so that I know what to post on the website for public comment, do y'all want to revise on 121 part 3? Do y'all want to change the word to may and say at the discretion of the board, or do y'all want to leave it as is, or do y'all want to do something else?
Vote from May at the
Yeah.
board's discretion.
I agree.
Yeah, I'm okay with that.
And
It may come up from
Yeah.
conversation later anyway.
And to address the issue of being able to go back, can you create a log of all the old declaratory statements someplace where someone can review them?
Look, always.
It's not our current statement, it's not our current position, but if they want to look at what the position was on this subject matter in 1978, get out.
So I do, yeah, I did. So the board used to, and y'all probably all mostly remember what, that the board had declaratory statements on the website, and they were all categorized by subject. Back in about 2015, 2016, at each board meeting, we would bring a group of these declaratory statements and review them at the board meeting, because there had been a rule change and things had changed, and that some of them were no longer even, the case, but there were a lot of them, and the board all had to agree to all the changes. And this took many, many, many meetings and many, many hours. And at one point, they were like, if you look at the Practice Act, these are really opinions. This is an opinion of somebody. Somebody said, hey, can a PTA do this? And then, they said no. And they voted on it, and they were like, it's not really supported in rule. And so they went through it with that lens of like, where are we supporting this in rule, or is this just an opinion of somebody who was sitting on the board at the time and have times changed? And at one of these board meetings, I can go back and look at the minutes, they decided to vote to take all declaratory statements down and to bring them up as topics came up that were important. Topics have come up that were important since then. One would be, can PTs do medication reconciliation in home health? What is the medication, process in home health? Things like that. We have a series of questions. We have one that's, can PTs practice on the sidelines of school sporting events? We have one that's, can PTs do ultrasounds? So things have come up in the past, and we have them under board statements on our website, because sometimes declaratory statement says that it must be a request. And sometimes it is a topic that comes up a few times, like the one about the sideline sporting events. It was there was a statement made by, I don't know, another board or something, where they said PTs can't do that. And so the board issued a statement without the request. And so we call it board statements. We can work on that to call it declaratory statements or something along those lines. I believe the APTA asked a question about imaging in the recent past. So I think that the process that has evolved until now, in my opinion, is a good one. I do have access to all of the old stuff. If anybody, if the board would, or the public needs that or whatever, we can put it up there. And whatever we need to do with it, sort it. But it is, and I actually reference it whenever people ask questions and it's historical stuff, and I need to bring information to you guys. I'll kind of look back through the old stuff and be like, well, this is what they used to do. And sometimes it's like, well, that's not the way it's done anymore. But so the information is still out there. It's still available.
Still there.
But they were teaching it in the schools. And so, that's the thing, is that you just have to be really clear about like what is no longer. I don't even, what no longer would be appropriate. And that might require coming to the board meetings and voting on each of these and all of that, which.
I think that like, if you're gonna have, if for some reason it's determined that those are gonna have to be posted, even in an archive manner, they're gonna have to be some type of disclaimer that these may not be appropriately accurate at this time, because things do change. Somebody's gonna cite that, like a court ruling, right? Be like, this versus this was the ruling, we're gonna go off of that. Because people will.
Sure.
People will. People say,
Yeah.
oh, I found this, it's in the archive, statements on the board website, we're gonna use that as our argument, or we're gonna just go off of that. So I think you gotta be cautious with that, have at least some type of disclaimer that can identify that, and it may not be the current stance of the board. practice act in its current.
For me, looking at this, we're trying to simplify things. And if we have to take old declaratory statements, evaluate them for accuracy, evaluate them for what it is now with modifications and rules, new statute. I think it's just complicating things. If you want to put something on the website that old declaratory statements are available by request, I would be okay with that, but to set precedent where we can be challenged on old declaratory statement, I think simplifies things. I think the point that Ben and O'Day put, that global impactful statements need to be there, individualized question don't need to be there, even if somebody takes a position that they can do ultrasound or, stand on the sideline. If it's not evaluated by the board to be something that's very impactful and sets a precedent not only for our community of practitioners, but also in a declaration to other boards that we have taken that position that you cannot challenge us on this. But for the general public to look at every minutia of things that have come in the past, I think it's just gonna increase liabilities for us to have to waste a whole bunch of time and evaluate those things. From a liability standpoint, is it gonna happen? Who knows? There might be, somebody that decides that they want to be a pest to the board, or it may never occur, but I think from a liability standpoint, we need to simplify things.
Yeah, I'd be in favor of what we decided.
Yeah.
Okay. Yeah.
Thank
Okay.
you, folks. Yes, go ahead.
So the publishing on the website, this is really the only mechanism that a licensee has to be able to get a sizable of the board that they can rely on, who they can rely on. In some cases, at least if it's an updated answer, demonstrating from this archive is no longer appropriate. However, this is the only way that a lot of licensees possibly could get the board's opinion on something. It is the board's opinion. That's what the board does. The board makes opinions. They issue discipline in accordance with their opinions, their total opinions. So anyways, this is how you can access that information. One point. Publishing it on the website is what makes that actually useful or valuable to licensees. Because otherwise they may not even know that the question has already come before the board, right? And so,
But it doesn't preclude them from asking the question.
you're correct. You may get duplicate questions, and I think I've heard words of past say this has already been answered in this declaratory statement. I'm positive of that. When you've already done the work on it and there's no difference in the outcome of the answer. But additionally, here, but I do feel that it is a valuable area licensees to access, and it would have helped when looking at Practice Act, not only rules, but also the statute revision. So I don't know what all declaratory statements the board has received, but I assume those are the confusing areas of practice. And so maybe those are things that looking at what areas should be addressed to make it more clear. Would have been helpful to access. I know in the past they were available. And if it's required right now, I'm not located on.
But that's where you have freedom of information. So you can always ask, is there any particular rule on, but to allow all this minutia, if I want it to be just a pest, I take one at a time and I keep bombarding the board with, well, what about this? My opinion on this is, and why did the board, and why this, and why that? And you just go down the list and you just become just an administrative nightmare. If it is a question, it can be asked to the board. It doesn't prevent the public from asking. And so it's going to be question by question. And if there's a declaratory statement, but it's still valid, then the administration can then reference and attach a PDF of, rather than having everything available. So again, my proposition of having global declaratory statement on the board website, and having if you have any further question, feel free to email. I think would be simplified, and I think the rule needs to be changed as we've discussed, may and at the board's discretion. I don't think the board is there to prevent you from asking questions in our rule.
Thank you, Todd.
Thanks.
Well,
Okay, so now we're in the final rule, which is 123, which is the definitions, and there are lots of them. So the first one that is proposed to be scratched is just, American Physical Therapy Association is APTA. So instead, APTA is found throughout the rules. And so on the next one, we added APTA as a definition and called it the American Physical Therapy Association. Didn't add, exactly what it is, but at least you know it if you're seeing it in the rules. CAPD, similar. Scratching CAPD, and then later putting Commission on Accreditation of Physical Therapy Education, CAPD in parentheses. Okay, the next one would be the continuing education year. So the continuing education year, this conversation will be a conversation for our next group of rules, which will talk about, a grace period after your license expires. This was a big discussion at our last practice session. And so the idea is that the continuing ed year actually should begin after the expiration date, which is April 30th. So it would begin May 1st, and then it would end at the expiration date, which is April 30th, which is not proposed to be changed. That period is not currently proposed to the board to change. Just a grace period is what we're looking at. Trying to simplify that whole process. Next one is on page 5, CWT. Instead of saying C coursework tool, it's unnecessary.
Chairman, before we move on to the other letters, we had a public comment.
Okay.
About the definition of continuous supervision. And public comment was that the definition of continuous supervision is problematic. And because of the confusion that it presents.
I think it was because of the word observation,
Yes.
if I remember correctly. Okay, yeah. Thank you, Lee. Yeah, the comment was that licensees, this question has come up in the licensing population, that the word observation maybe should be scratched. And it's because it also says who is physically within the same treatment area. So if you're in the same treatment area, then that clarifies enough that you don't have to be observing. But I have found that language helpful whenever people are confused about continuous supervision, because I'm like, well, could you observe? Like, are you in the gym and can you see them? Would you be able to, versus, are you behind closed doors or behind a curtain or something like that where you can't observe the care? That's how I've helped people think through what continuous supervision is. But if the definition changed, I would, probably not ask that, like, can you observe? Because it wouldn't be in the definition anymore. So that's something to think about.
Chairman, I would make a recommendation for the board to consider that we scratch the definition of continuous supervision completely, and then add a definition for direct supervision. The board has the authority to adopt codes, guidelines, standards of the American Physical Therapy Association and the American Physical Therapy Association in the House of Delegates of 2019 has a definition of direct supervision that the board may consider. Alternatively, there's also a definition for direct supervision in the Occupational Therapy Practice Act in rules that the board may consider. And so the definition of direct supervision from the House of Delegates of the APTA is direct supervision applies to the supervision of student physical therapists and student physical therapy assistants. The physical therapist or physical therapy assistant, when supervising a student physical therapist, is physically present and immediately available for supervision. In both cases, physical therapist or physical therapist assistant will have direct contact with the patient or client on the date of service, and telecommunication does not meet the requirements of direct supervision. So that's from the House of Delegates. That's their definition. We could adopt that as our definition of direct supervision. Alternatively, we could adopt, the definition that is in the occupational therapy rules. And this is specifically, rule 1903A, under Louisiana Administrative Code 46 XLV. And our adoption of that, would be that direct supervision would apply to the supervision of unlicensed personnel, students, physical therapists, student physical therapy assistants, physical therapy technicians, and licensees requiring a period of supervised clinical practice, including foreign educated physical therapists, foreign educated physical therapist assistants, provisional licensees, and licensees who've had their licensure status changed from inactive to active, who have required reinstatement or suspension of the license for a period of greater than 4 years. And direct supervision requires that the physical therapist be present and immediately available, to the patient, at the time of the date of service. So by getting rid of continuous supervision and replacing it with direct supervision, I think it may provide greater clarity for licensees. It would require, if we do that, then all subsequent language, that in the rules that relate to supervision, would, use direct supervision, as the statement. And we could refer back to the definition.
Capacities, like.
But it does say continuous supervision, you are physically within the same treatment area. So it's almost direct, but it's a different verbiage, correct? Are we just saying the same thing, just changing them? It seems like we're saying the same thing, because
The comment from the licensee, was that it causes confusion. So in the interest of clarifying this and providing greater transparency for licensees and for the public, there is general supervision, which in the House of Delegates definition, general supervision relates to the supervision of physical therapist assistants. A physical therapist does not need to be physically present, at the time of patient care that is administered by a physical therapist assistant. They do need to be available by telecommunication, and that definition aligns with the requirements that are established in our statutory language under 2418 F2C. So general supervision would be the supervision that would be applicable to physical therapist assistants. Direct supervision would be applicable to all the other instances that I.
So if we change the level of supervision, just to let you all know, because right now, continuous supervision means that you can observe, like you're there, you can see. What you're talking about is on-premise supervision would be available to, like, immediately available to.
this is within the same treatment area. Continuous, which is the same.
Yeah,
But this-
she's referring to the direct, like being more of a broad.
Yeah, so direct says immediately available to the treatment area. That's on, if you look at on premises supervision, that's more related to what that is. It's just right now we have two different, if you're in the facility. One is continuous where you got eyes on, and the other one is you're in, like maybe down the hall. And so would you propose scratching both on premises and continuous and just saying direct instead?
I would, for the board to consider, I would propose that we have a definition for general supervision and we have a definition for direct supervision. And we can align that definition with the established position of the American Physical Therapy Association and their position from 2019. Or we could consider adopting language that is already in law that applies to occupational therapy providers.
So I'm in complete agreement with what Lee is talking about. And I'll play devil's advocate for a second. One is going to be on the standpoint of us protecting the public. I don't think there's any time where I didn't have eyeballs on one of my unlicensed tech that I personally trained to supervise and exercise. I don't think that any of my patients have been in peril or any you know, threat to their welfare by me not having direct eyeballs on the tech as they're doing their thing. And not only that, it is absolutely impractical from the standpoint of if I am working with Ben, for example, directly, that I'll be looking at Charlotte as she is supervising something that I created as part of the plan of care for that particular patient. So having all of those regulatory things and wording and all is basically babysitting a professional in their professional judgment and creating levels of hurdles that makes it a lot more difficult and a lot more liable for them to get in trouble if somebody decided to say that, well, the therapist was in the room, but I was on the stationary bicycle and they weren't looking at me. Well, based on this, I have to have a direct eyeball on, rather than being available on premise at all times or even in the same room at all times. So I think that having established definition makes this have a little bit more latitude, basically tells the professional that they are professional and their professional judgment does count rather than babysitting them through, you need to, you know, be within arm's length of the patient that's being supervised by an unlicensed, and I need to be within eyeball distance and I have to keep my eyeballs on that patient. It becomes too impractical from a therapy standpoint.
I would be in favor of adopting the directive definition.
Just a question, if y'all do that, if y'all tell me if I'm in new definition of supervision that's added, would you, in this draft, would you take that out to not have it? Because then that allows you to do it remotely, it's deemed appropriate, or
I think it would be unnecessary for us to have additional definitions of supervision if we align the definitions with the definitions of the American Physical Therapy Association. And if we align the definition of supervision with what is already in law, for the occupational therapy providers. So
You have the distinct of the two, right? Direct supervision and the
there's general supervision.
general supervision.
And
Still
general
separate.
supervision only applies to licensed physical therapist assistants.
And that was
And general supervision does not require you, to be immediately available at the time of patient care. You need to be available to telecommunication.
right.
Direct supervision requires you to be immediately available to the patient at the time the care is being delivered, if it was.
then you would delete, in my opinion, if you want to do that, you would delete this newly added definition of just supervision.
I would recommend that so that it just clarifies we
Yeah.
have two levels of supervision.
Well, whatever it is that we do, what we can't do is impede upon the utilization in Louisiana, is impede upon the utilization of unlicensed supportive personnel. End of the story. Legislative history and legislative intent at the time of licensure of PTAs. And again, Louisiana was the last state to license PTAs, okay? I love my PTAs, but here was the direct instructions from the legislature. You can't create another level of licensure that's going to increase compensation and increase cost and put these people out of the ability to have a job. Okay, now, when we get to rural communities where we can't recruit PTs, can't recruit PTAs, you're a one-man clinic. You may have 6 unlicensed supportive personnel to meet your ratio, okay? And, now, it never, ever was intended for unlicensed supportive personnel to be able to treat a patient without the PT on the premises, okay? So now, along the road in the mid-'80s, we put in this supervision clauses because there was a need for unlicensed supportive personnel to assist the PTA when they were on another floor in the hospital, and then PT couldn't have their eyes on the unlicensed supportive personnel. Okay, so then we put in here that, you know, a PT, unlicensed supportive personnel can assist the PTA in gait training, safety, ambulation, and functional activities. All right. Now, today, the law says that the PTA can go and practice in the clinic alone without the supervision of a PT. Okay? And then the question is, can the PTA have one or two techs to assist them in doing their job? So the confusion is PTAs, the only supervision requirements that they're gifted is supervising student PTAs. Okay? It's always the PT's job to supervise the unlicensed supportive personnel. But can the unlicensed supportive personnel carry out the part of their treatment that was assigned to them and trained and then documented in their personnel file, as the rule says, to then go on another floor in another building or at another office and assist the PTA when there's not a PT there? That's the question. How we define supervision on premises, direct, it doesn't matter. What we can't do is impede upon the physical therapist using his unlicensed supportive personnel how he or she feels appropriate. And then is it appropriate that that person can take those skills and training that was given by the PT and then go off site or out of site and assist the PTA? Now, however we do the definitions, it doesn't matter, but we can't lose that premises. That's the whole premises of the legislative intent of us being able to continue to use unlicensed supportive personnel and us having PTAs. Now, some states, they disallow the use of unlicensed supportive personnel. And those states think that people in Louisiana are unethical, or the other states where, you know, we're not the only state, but they think that we're unethical because we allow somebody other than a PTA assist in our care. It's just the genesis of this practice and the legislative intent and the history. And again, we're trying to increase patient access, decrease barriers to access to care, and decrease administrative burden, and have clarity. So how we do it, I think we understand that there's comments from everybody on this supervision, and how we write it and how we define it is immaterial as long as we don't broach on the right of the unlicensed supportive personnel and the PT to use them how they see fit.
That's where I'm coming in and trying to
Yes,
establish that the PT is the profession.
yes,
The unlicensed person, the licensed PTA, the student, the foreign trained therapist is a tool. So if you trust in the tool, you train the tool, it's no different than having an ultrasound machine that you're using, trusting that the machine is properly calibrated and doing what the machine is supposed to be doing, and having a means to evaluate that machine. So when I had ultrasound, which I'm not using anymore, I had an independent person coming in and evaluating the proper functioning of. Well, in the case of unlicensed staff, I am doing monthly training with my staff to make sure that whatever I choose to delegate, where they're not within my eyeballs, that it is performed to the standard that is required by me, making sure that it is within a skill set that doesn't require a professional. So supervising patient going from one equipment to another equipment doesn't require me to have eyeballs, and I'm just using the tool, which is my unlicensed staff, to bring from point A to point B. If they're doing a leg extension exercise and I teach them how to do terminal knee extension, I've already evaluated the patient. I feel the patient can be with minimal supervision of an unlicensed staff. I am using my tool to make sure that the patient is properly motivated, that they carry out the exercise properly, and I don't need to have my eyeballs right there, but unlicensed staff, as to Lee's point, unlicensed staff, I need to be in the clinic. I need to be reachable in case something happens, in case a question from my unlicensed staff comes up, and or something that deviates off of the plan, and they say, hey, Claude, can you come and check? And I don't think that they're using the right muscle. What would be a good way? Or how can you teach me to supervise this? And then for the rules and statute that we have with licensed PTA, then the general supervision, comment that Lee had is on point. The O'Day's point, I was kind of juggling a couple of different things in my head. If we have general and direct supervision wording for the PT, do we need some for the PTA also to limit the scope of what direct supervision is? And if they have general capacity for which, PTs don't. So we wouldn't have the general supervision because that's, a skill set or a professional liability that should only befall the physical therapist, but having a direct supervision of unlicensed staff and the number of those unlicensed staff the same as what we have for PTs.
Yes.
So in the definitions of what supervision is, do we need to have language for PTs and PTAs? Incorporate the PT and PTA within what the definition of direct supervision is? Can we do that efficiently?
Mr. Chairman, I would suggest that the supervisory requirements for physical therapy assistants is defined under the statutory language under 2418.
Sure.
So the supervision of physical therapy assistants has been established.
Yes.
And that is established, by statute. So in terms of definitions, what I would suggest is that my suggestion for the board to consider is to just clarify what is the definition of general supervision, what is the definition of direct supervision. We already have the statutory language to let us know supervisory requirements for physical therapy assistants. Correct.
Go ahead. Go ahead.
So the Model Practice Act has already done this, a considerable amount of work for y'all with regards to this. They have a definition of supervision and they have a definition of on-site supervision. And they also provide commentary on that. They go into why they chose on-site supervision and what that actually means, how that should be interpreted. Additionally, I think that the confusing part of the continuous supervision is it says observation and supervision of. So observation could actually, that could occur by seeing something visually, noticing something, hearing something. So it's maybe, I'm not sure, maybe at least can comment on what would the legal definition of observation be, but it doesn't, it's not just visual. So I think that's what makes it a little bit confusing. And we use the term, we were trying to define continuous supervision, where we have the Model Practice Act calling it on-site supervision, what that means. And we have the APTA Health Delegate Statement, which is calling it direct supervision. And they also have a direct personal supervision definition.
We can add more words and more words, and the more words we have, the more confusion can arise. I think Lee has it on the ball in the definition that he gave, and that leads to enough support to the fact that the PTs and the PTAs are professionals. They have professional judgments. And to my point that I brought up a couple times so far, is we are innocent until proven guilty. The element of a physical therapist that doesn't do their job is going to be found. And when they are found, they will be properly evaluated by the board, investigated, and see if they use professional judgments.
So it sounds like the recommendation is for backing up from where we were, coursework to CWT. The recommendation is to scratch continuous supervision in the one that we post online.
Change the definition to direct supervision.
And we will add those,
Both of them.
general and direct
Yeah.
supervision, but to scratch, are we scratching in the one that we post for public comment? Are we scratching continuous supervision as currently defined?
I think that would be the
I think so,
suggestion.
yes.
And you need to scratch supervision.
And on-premise supervision.
Yes. I was.
So to Amanda's point, it could be offsite, onsite, instead of general, direct. It's just semantics at that point, but I think the spirit of it is in the definition that Lee provided.
Yeah, I think the direct shows the on-site and the general shows
Okay.
the
Clarity, real quick on clarity.
within the definition.
A PTA can treat with technicians if a PT is not on site. Yes, no, what is it? Because they have supervision rights from the technician. And a PT is available by telecommunications.
I'm
What is y'all's thoughts on that?
I'm going to assume that as we go through the rules, not in today's session, but at a later session, we are going to address the supervision, we're getting ahead of ourselves. I would just suggest that we're maybe getting ahead of ourselves,
It seemed like
that we are going to address the rules and the language surrounding supervision of unlicensed personnel.
Right.
So my recommendation for today's session, because we are covering definitions, is that we scratch continuous supervision, we scratch on-premise supervision. We scratch the definition of supervision. We create a definition for general supervision, and create a definition for direct supervision.
Okay.
I feel like
It's a
both-
definition.
Seems like we're going that direction.
Yeah, I feel like both those definitions are a lot more straightforward, a lot less question of how you're gonna interpret certain words, observation, et cetera.
And in later rules, we're gonna look at the functional aspect of the
That's
definition
not today.
and what it.
We'll use those words.
Yeah.
Because currently we don't use.
We'll have to apply those words
Right.
in future rule revisions so that whoever is reading the rule can refer back to the definitions when they're looking at that term, direct supervision or general supervision.
Do we need to define better unlicensed? Because there was a conversation or a confusion of front office staff.
I think that's coming.
Yes.
Okay, we'll continue moving on. I think we have SSA waiting on us. I'll be trying to 30 more minutes.
So,
Yeah.
but by CWT.
Okay, thank you.
Thank you, Lee, for that.
So the next rule is discharge summary. It just says see documentation standards, so we're scratching that. Propose to scratch that. We do not propose to add any sort of definition to discharge summary if it exists. So we're not providing guidance on discharge summary here. Documented conferences, again, the reference that is there now is no longer being referenced. And also, we used to define it in patient care conference, but we're proposing to scratch that. FEPT, FEPTA, foreign educated physical therapist, foreign educated physical therapist assistant, and foreign educated PT applicant are all recommended to be scratched. And those terms are used in the rule where it applies. HIP DB is what used to be the National Practitioner Data Bank. it's an outdated term. It's proposed to add informed consent as a definition. This definition is from the Informed Consent Guide for Physical Therapy, 2025, that was published by the FSBDP. We only used the first sentence and didn't use the other sentences in the definition.
I think there was a comment that was sent possibly by Katie talking about informed consent, that the only place in statute that informed consent is used is in dry needling.
Mhm.
All right, and we're proposing a rule that gives the patient informed consent ability at any point in time during the treatment, but that's not necessarily mentioned in the statute. Can we legally define informed consent in rule when it's not mentioned in statute in the general consent context that we're doing now? That's the discussion.
Thanks. The comment I would make, for Chairman and the board to consider is that the statutory requirement for informed consent is part of Louisiana law. There is the Louisiana Informed Consent Law.
Yes.
It is, Louisiana Revised Statute, 40-1157.1 and established in 2015. So there's already statutory language regarding the requirement to obtain informed consent from a patient for medical treatment and surgical procedures. And the guidance for how to obtain informed consent is in statutory language. So to Elisa's point earlier, whether or not we need a definition of informed consent in our rules is the question, because it's already part of statutory language for the provision of medical treatment in Louisiana.
So not having a statute, we don't have a shall, so we don't need them.
Correct. We don't need a rule necessarily unless the board thinks that it would be prudent to have. I think one of the benefits of having a definition is providing some clarity to your licensees about how to go, instead of having to go search the statutory law to establish what is the standard here for physical therapy. How should they go about getting informed consent? But no, it's not required that we.
Can we, to O'Day's point, can we create a definition off of a non-existent statute? Since our statute only applies to dry needling.
That statute doesn't preclude the board from adopting a definition of informed consent.
Okay, so if it's not statute within physical therapy, but statute within the state, we can make a definition off of the statute of the state within our rule without having a reference statute of
Sure.
ours.
That's within the general authority of the board to adopt rules to enforce the provisions of the Practice Act.
To be helpful to our licensees, I would like the board to consider something that I didn't consider until just now. We have a definition of the minimal standards of acceptable and prevailing physical therapy practice. And we reference, the code of ethics, and maybe we could also reference that there is an informed consent law that exists in Louisiana, and that could be part of a minimum standard. And that way they, because it might be hard for them to find all the Louisiana laws that apply.
Alternatively, we could reference the law in the definition of informed consent. If we have the definition of informed consent, then the board could consider referencing the Louisiana Uniform Consent Law and the statute in the definition.
And can we not add in that definition the requirement under minimal standard? As per a minimal standard under the revised statute, which is the state law.
I would think that maybe you should all consider if the definition as found in law is sufficient, or if it's not sufficient for the practice of physical therapy, and your own definition should appear, in which you probably want to reference that.
I was just thinking on Elisa's point that it's a point of clarification for our licensees, and it is definitely from a protection of the public, considering cases that we had before where physical therapists didn't inform the patient what they were about to do, got secondary consent, before they, obviously did something that the patient felt was crossing boundaries. So at that point, if there is a complaint, it is already in the minimal standards and defined for their ease of reference.
This doesn't say anything different than what the statute says for all providers. That's my opinion. I'll just write more language. You know,
So for the purpose of posting online, rather than adding additional language that just mirrors language somewhere else in Louisiana law, would you all, how would y'all like us to post this online for the public to consider it?
I think the definition as it stands, what I would recommend is to leave, so we can get public comment. Because I think that's valuable for us to get public comment,
Okay.
in considering moving forward, how we're going to do this. I think the definition is a great definition. My recommendation for the board would be, let's leave it let's post it, get public comment. If we do decide to add to it a reference to the Louisiana statute, then that's a decision that, that we could consider.
Public comment. Amber,
Go ahead.
currently, I'm not seeing informed consent in our statute. I'm only seeing it in the rules, so 311D regarding treatment with dry needle. I don't see it anywhere else, and the proposed definition as written does not seem to only be limited to dry needling, so I'm not sure what the intent, if the intent is to cover more broadly than dry needling. Not in statute, and it's only in dry.
Yeah, but that's what we just finished discussing, that there is a state law
applies to all providers.
that covers, and we have a statute for dry needling. But the definition is just for the ease of understanding of our licensing. It doesn't need to be done, it's just good practice to make sure that they understand that the minimal requirement is get informed consent from your patients. Educate them before doing treatments.
Mr. Chairman, as a point of clarification, there is no statutory language regarding dry needling. It is a rule promulgated by the board.
Yes.
So the provisions around dry needling were rules promulgated by the board. And so they are not statutes.
They're not in the statute.
They're not statutes passed.
Right.
The rules promulgated by the board have the authority, of law.
Since it's not a shall for us on dry needling, can we just have us scratch that section of informed consent for dry needling specifically and just talk about all the different
That's-
procedural stuff?
That's down the road.
But in the definition of informed consent, if we have informed consent in the definition, do we need to redefine it again in dry needling?
I would suggest that we have one definition for informed consent. And so that it's clear what, informed consent is. My recommendation would be that it aligns with existing law, and the requirements, if we do take language that was proposed by the Federation of State Boards, that's perfectly fine. But I don't think we should have two definitions of informed consent. We should have a uniform definition of informed consent that complies with current statutory language. And it makes it clear to the licensee what we mean when we say informed consent. I'm not aware of how many of our licensees are aware that there is a uniform consent law in the state of Louisiana.
Yeah.
So to Elisa's point, it may be helpful to have a definition of informed consent.
Lovely.
Particularly if there was a disciplinary action in which we, as part of the investigation, we determined that informed consent was not obtained, then we can reference the definition, in any disciplinary action.
Okay, and just to let everyone know, we have about 5 more minutes, and then Danny said we'll take a bio break, and then we have special guests coming in at 11, and then we can, after they interview, we can start back up. Okay, just so we know where we are. Okay, so, following the informed consent, it sounds like we're just gonna leave it in as is whenever we post it. Get some public comment and bring it back. Okay. Initial physical therapy evaluation, it just points to the statute, so it's being recommended to be scratched. This is Louisiana Physical Therapy Practice Act, it's recommended to be scratched, and then whenever we go to the Ps, we'll talk about Practice Act. MEPTA and military educated PTA applicants. Again, those are just referencing a rule in which we have licensing procedures for those. And it's not really necessary to put those in there. NPDB is National Practitioner Data Bank, which is later defined with a parentheses of NPTE. NPTE, we just added the NPTE after National Physical Therapy Examination and took out the acronym as a definition. I have in my notes that we are proposing to scratch on premises, which was not a supervision definition that was scratched prior to coming into this meeting, but whenever we post it online, we will propose scratching that. And again, general and direct supervision from the APTA definitions will be added to the document for public comment. The next definition is participate. So participate is recommended to be amended, Part B, to say 12th treatment day instead of the 6th, as per the statutory change that occurred. And to scratch whichever occurs first and say, and for the final treatment session. Any comments on participate? Patient care conference is recommended to be scratched because it just says reference documentation standards. That language is also being proposed to be removed from all rules. Physical therapist, it just points to the statute. So it's recommended to scratch that definition. Same thing with physical therapist assistant. Same thing with physical therapy, and same thing with physical therapy evaluation. The next definition is physical therapy technician.
Chairman, I have a comment related to this definition. Sure. The commentary indicates that this was a definition from the Model Practice Act of the Federation. And so the exact language of the definition for a physical therapy aide or technician is a person trained by or under the direction of a physical therapist who performs designated and supervised routine tasks related to physical therapy services. The language that is in this definition also includes language that from the Model Practice Act relates to physical therapy assistants. So the definition of physical therapist assistant from the Model Practice Act is a person who is certified or licensed pursuant to this act, who assists the physical therapist in selected components of physical therapy intervention. In the interest of not causing confusion, for our licensees, if we're going to adopt definitions from the Federation, we should not change the language of the Federation's definition if we're going to reference the Federation's Model Practice Act. I think it just causes confusion.
So the version that you read was pretty much the same thing except for after supervised. The components is not there. The components of care is different. What you read, but you would want to adopt with the verbiage of what you read. Routine.
If we're going to adopt language from the Federation, we're going to adopt the Federation's definition.
Right.
I think we should adopt the language that is the Model Practice Act related to that definition.
So
So
routine.
it is a person trained by or under the direction of a physical therapist who performs designated and supervised routine tasks related to physical therapy services.
Just removing components of care, replacing routine tasks.
Is everyone okay with us updating the language to reflect exactly what the mock practice act does? Okay. Okay, it is 10:46. And so, Mr. Chairman.
Take a bio break,
Thank you, Mr. Chairman.
and then I believe we come back.
I can appreciate your.
Can we finish? Can we finish?
my.
Can we finish this? Go take a break? Yeah.
Bio break. You can stand up and shoot right up in the bio break.
Oh, they requested to finish it before we take a bio break?
Tires.
It's up to you.
You know,
Much time.
I think we pretty much covered most of the, maybe not.
I think we got,
Okay.
what do you think?
Take a break.
Probably 10 minutes. You have, you brought those bars?
There are protein bars up here, and we also do have a tray of sandwiches coming at around 11:30.
Ah,
Yeah, we said that, you know, about two thirty, I was like, oh, man, I'm. My life support, but I believe the NCP.
I'll put it past her. Having press with nominated. That's when you pull in the green stamp.
Yeah, I have to see how things go
Yeah.
next round. I think we'll be in very. Very nice.
Yes, 100%.
Yeah, yeah, sure. Thank you for your time.
Yeah.
where is it?
The practice act committee meeting update. Charlotte, not. Comment. We don't have anything for it. Hey.
What? Think, Luke's all the good last, so. Yes, Luke, I mean, the evaluate up Luke.
Yeah.
Okay.
And.
I need to, but as soon as you don't, you don't stick back, so I think you have to.
Yeah. Men?
Yeah.
Yeah.
Well, I would really like to know, you know.
That's correct.
Who's in the wrong profession?
Somebody not sure.
No. Bigger than the dog. Deregulation.
Deregulation. Not D. What's the one that covers this one? The D. Deregulation.
Yeah. You thought. There you go, there you go.
Anyway, so rock the boat.
What do you make that?
We're gonna have.
No, invite that. If you, kill himself, get your back.
I have to tell you, but you know what they do? They bring the patient from point A to point B and they clean the room. I do all the treatment rooms, teach all the exercise, all that stuff.
The last point. What's the last thing we did?
General supervision.
No, very last. The,
PT tech definition.
yes,
Yes.
yeah. The PT can only, the only PT checks it does say.
It's flat, maybe it's a top.
We're not saying that in the rule.
Really doesn't give PTA supervisory role of anybody other than student PTA. PTA don't supervise. anybody.
Yeah.
The question is now, can the tech, of a PTA there.
But that's gonna be,
That's all.
not in the definition of, because we're gonna have general.
I need to talk.
But in the. Practical aspect.
Just so.
No, not that.
Give me a thought.
In the
I
function.
mean, they're here, so they'll come work together. The key is also here.
And there's been some.
And so I would recommend that after
O'Day
they
said there
go,
was
rather
three.
than going right back into the rules, we let them come in. So you-
No, there's, his one is a very good person to bring. I don't know everyone, but I know several very good people.
He said that-
There's a willing and able.
He said they submitted
I
3
think that
days.
would be a nice.
Yeah,
Okay, so she-
I mean, some next.
they said they got a good group,
Yeah, very good.
but no.
Banana.
I'm
You got enough, you have enough irons in the fire?
so busy.
Like the trigger.
Oh, but,
What-
Danny.
So-
How many open positions do you guys have in practice?
Well, just made a bunch of hires. and then they
Okay.
have the-
Is it ULM?
One more, yeah.
We had one from ULM.
Rocking the boat.
So you'll want to amend the agenda.
So I'm gonna be working with those.
Just don't know.
Trying to get the.
Well, you may have. What's?
That have the strategic strategic plan, but right here, so to have the strategic plan moderator and facilitator contract
We need to,
heard now.
oh, we have this guy already.
I would do them and then him.
Then
we will do here.
This lane.
This
Uh,
and
I think we have
this,
like
which is 2 lines.
whatnot.
and then we'll go back to-
They-
So we'll pause on the roll.
Yeah, roll call.
We have to do a roll call.
Yes. Yes.
That was reading through the. I think the roll.
Very different perspective. Yes. I'm sorry.
What I'm thinking is it, so for like, to take the.
You know, no,
To the point that we're having.
Right.
Is the fact. that
Right, right.
It's part of it, I know. So if they're graduating in May,
Why?
and they take. away the
Okay.
Okay.
Yes.
Versus if they're waiting until July.
I know the FSBP.
Very Yes.
For you.
They only-
All they publish is first time.
Y'all
Just
made-
in the profession. Better and better.
Yeah, I know, you know.
Right.
We need to know.
Yeah. Yeah, yeah. Yeah.
And we don't. And we don't want
If they.
anyone coming in front of
Yeah.
us.
Yeah.
Saying, why, I wasn't aware.
Yeah.
I've been.
Yeah.
So if every. Recycling.
Is the ones.
Or recycling here where we do our lives.
It's a great idea.
Mandatory.
Yeah.
It's on passports.
Correct.
And we don't get eligible.
Mandatory.
I was thinking is
So it's just.
Mandatory.
I was trying to read them. To hear what they have to say, you know, and then.
Did not.
That's it really helps.
And she just.
and
Yeah.
And we're like.
So, what they want.
I use, I like. Take all It is consistent.
Honest. It doesn't certify somebody, but it was stretching.
And it was so blurry.
It
and
does
It was like an
provide
image of my
business
hospital.
standpoint,
But it was so blurry.
But you can
They
get
could
these
not, it didn't identify any other than that. But the question was, like,
That just covers that cost.
yeah, it's exactly.
Question here.
But in.
Busting up to it, busting up, it's fine.
Right, it was not about the bed, it was about.
Second is watching, you listen to the whole.
All right, children.
Back in touch. And the fact that these issues.
I thought.
So it's good.
You know, be like.
And both of them, even down. Because.
But I-
Model for them to make.
That's when Charlotte, I missed go for that.
Okay.
So, you
Now, okay.
know.
Okay, y'all believe we're gonna do something?
We were excited. I think.
Getting them off?
We'll spend what?
No, we have a quick agenda change. Yeah, sorry about that. We have a quick agenda change here. They call over. There we go.
All right, appreciate that.
Again, a quick agenda change. We have strategic planning moderator come in. For a few minutes, I've been waiting a little bit. We'll come in and talk to us for a few minutes. And then we have a licensee waiting outside, been there since 9. We'll have him come in for a few minutes. He wants to change suspension to probation. And get that done, then we're back to the rules and get that knocked out. Correct?
So in order to amend the agenda, we need a vote.
Yeah, we did a roll call.
We need a motion.
We need a motion.
Sure.
Yes, Mr. Chairman, I move that we amend the agenda to accommodate the guests that have come to today's meeting.
I'll second it.
All in favor?
I'll take a roll call.
Roll
vote.
call for.
It has to be unanimous. Okay, so Danny Louis,
Yes.
O'Day Laverne,
Yes.
Adam York,
Yes.
Lee Riley,
Yes.
Michael Hildebrand,
Yes.
Claude Tremblay,
Yes.
and Ben Gaines.
Yes.
Okay, it is unanimous. We can amend the agenda.
Okay.
Yes. So we have our first guest speaker here, who is Don Snow. He is representing Emergent Method. And so the next item on the agenda is to discuss our strategic plan. It is ending in December, and so we are looking to do a new strategic plan, and we have 2 potential vendors who are interviewing today, and you all have received 3 potential vendor proposals along with work product examples. So John, we'll turn it over to you.
Okay, great. Where's that stand? Where's that stand?
Oh, why don't you come here?
Okay. Yes, I saw you get the Zoom up.
Thank you.
Well, thank y'all for the time and the opportunity to propose on and work with your board on this effort. As Charlotte mentioned, my name is John Snow. I'm a partner in Emergent Method. I've been with our company since the beginning. My business partner, Nick Spire, founded the firm in 2012. I joined him in 2013. And we've been really honored and blessed to be able to grow significantly over time over the last 14 years. Actually, our anniversary of our founding is actually this month. Growing from just the 2 of us to a team of about 170 full-time employees. A big chunk of that workforce is here in Louisiana, but we do work all across the country. We're in about 20 different states or so. But really over time, we've had the opportunity and fortune to be able to work on some of Louisiana's most important initiatives, largely being strategic plans. That very much is in our wheelhouse and kind of bread and butter, the foundational kind of work that we do. That's everything from working on CPRA's Coastal Master Plan, dating back to when CPRA first became a thing, when then CPRA had Garrett Graves came in under Governor Jindal to start up the organization all the way through to all iterations of their master plan. And as recently as a couple of years ago, working with the governor's office and LED on the development of a new economic development strategic plan for the state, which was their first in the last 16 and a half years or so. And really everything in between. I believe we've worked with most, if not all, state agencies, the cabinet level departments, if not directly, then certainly indirectly. Our work also is heavy, and we've spent a lot of time in the healthcare space as well. So We've had the opportunity to work with agencies like LDH coming out of COVID. A big effort that they were trying to do internally was understand what is our organization like, what is our culture like, what is our workforce like, knowing that they, probably more so than really any agency at the state level, were taxed significantly through the highest points of COVID. And so coming in to help them understand the current environment and how they needed to reposition and kind of operationalize coming out of that period of time. We've worked on the private side, working with Fortune 1000 companies like Amedisys, developing their strategic plan and annual operating plan, to working with hospital systems like FMOL, Our Lady of the Lake, helping to facilitate and grow their championship partnership they've had with LSU, a $240 million effort they entered into about 3-4 years ago. And really everything in between. On the education side, we've done work everywhere from Kansas State University, working with their College of Health and Human Sciences, to here in Louisiana, developing a strategic plan for the LSU School of Medicine in New Orleans. And so really when we think about the work that we've done, I think it's all at the intersection of public sector work and also kind of sprinkled in different sectors where we've got a lot of experience and opportunity here. In particular, on the system side, we've had the opportunity of doing a number of projects that were focused on developing higher performing organizations and systems that power things like healthcare. And so leading the overhaul and modernization of the state's Medicaid enrollment eligibility system here in Louisiana and for several other states as well. Specific to myself, as I mentioned, I'm a partner in Emergent Method. I lead most of our strategic planning organizational efforts, like the one that we proposed here today. Y'all probably couldn't guess this, but I've also played a little bit of basketball in my day, which means I've broken a lot of bones in my day, which means I've gone to PT many a time. And so I'm very thankful for the work that y'all do, that this board does, to make sure that we have high performing, well-regulated physical therapists here in our state. Our team is largely composed of myself here in Baton Rouge, and then my colleague Kelsey McCrary, who is actually based in Monroe. Prior to joining our team, she served as the planning lead for the state's Office of Cultural Development. And then for the last 5-6 years or so, has been chief of staff and head of planning for Mayor Friday Ellis in Monroe. And so I think that's one of the benefits that we bring to efforts like this. You know, y'all do serve all of the state. You don't just serve Baton Rouge or one specific area. And the benefit is we have teams that are, you know, kind of crisscross the state. While we do have a high concentration of folks here in Baton Rouge, we have folks that really live and operate in all portions and corners of the state. In terms of our process, and I know you've got our proposal in front of you, and you probably have had a chance to flip through, so I'm not going to, I know y'all have a busy and packed agenda, so I'll try and keep it brief. But we really approach strategic planning and what we like to say is it's very stakeholder driven and data informed. We know in the world that y'all are in as regulators. I've also had the benefit of serving on a board like this. Governor Edwards appointed me to the Louisiana Highway Safety Commission, and so I served on that board for about 7.5 years or so. So I know the weight that comes with serving on a board like this that you owe to the citizens and certainly the practitioners of the state. Our approach here is to make sure that you've got really good data and insights in terms of where you've been organizationally, where your field has been operationally and across the state with all of the licensees that you regulate, but also understanding what are some of the best and more innovative practices that are out there across the country. Part of our approach is to look at what we like to call peer organizations. So those that y'all would think are kind of analogous to the work that y'all do in other states, but also those that are considered to be best practices that are incorporating some really innovative things in the programs, the way they institute licensing, maybe some reforms they've undergone, so that we can beg, borrow, and perhaps even steal some of the things that they do really well and adapt them here in the Louisiana context. We have a heavy approach to stakeholder engagement. Again, you'll see it in our proposal where we propose doing a mix of interviews, focus groups, surveys of your licensees to understand sort of maybe any friction points that they have interacting with the board and the agency. And then also understanding, again, organizationally, where we've been, where the industry has been here in the state. And then we would take all that information, wrap it up into a really robust set of research findings, bring that back to the board, have a half day or a full day retreat at your convenience to talk through what are all the things that we've seen and heard in our diligence and our stakeholder conversations and our research, and then package that up into a strategic plan. So that's really what we've proposed. We would very much welcome the opportunity to work with y'all. I think very highly of the work that y'all do. I think very highly of ODAVE. I've had a chance to work with on a few other efforts here in the state, and so we certainly would welcome the opportunity to work with y'all. I know I went through that really, really quick, but again, I know y'all have a packed agenda, so I'd be happy to answer any questions y'all may have.
If I would comment while John's in the room, and I'm sure we'll comment when he's not in the room. my first exposure to emergent method was at the England Economic Industrial Development District, or the Alexandria Airport. For the first time in 32 years, the new executive director, who had worked with emergent method before at both Baton Rouge and Moisant, brought a concept of a strategic plan. This organization's been in business for 32 years, never had a plan. Hard to get someplace if you don't have a plan, right? So did a phenomenal job of surveying the market and finding out what the community needed, what the stakeholders wanted, and did a wonderful, strategic plan for that. The other place that I've had to opportunity to work with them is at an organization called Louisiana Central, which is our 10 parish private economic development organization. They work very, very closely with LED, Louisiana Economic Development. So Emergent Method did the strategic plan for LED. Emergent Method came to Central Louisiana and did a strategic plan with all 10 of our parishes in order to make sure that our strategic plan melded with the state strategic plan, and it was a phenomenal experience. One of the things that John did is we hired a new executive director, and this gentleman set out a 100-day plan that he was going to visit all 10 parishes and meet 100 business during that 100 days. He met 700 business owners in 100 days. And John was in his back pocket and his hip in the car and the bus every day for almost 100 days. Okay?
Yeah.
A tremendous opportunity, a tremendous work product out of that. So I've been nothing but pleased with what Emergent Method has done, and John in particular leading their team. And I'll also say that John just was won an award from the Manship organization here. So congratulations, we've got an award-winning guy here, and he's done some wonderful work.
Thank you very much. I appreciate that. Thank you, John.
All right.
Thank you, John.
Thank y'all very much. I appreciate it.
Do we really believe we can get this done by the end of the year?
I believe so. I think that that's largely going to be contingent on the responsiveness of stakeholders. But we can move as quickly as we need to. So I really do feel like we're here in mid-August, assuming we move forward, and we're able to get a contract done very quickly, which I assume we will. That really gives us September, October, November to do the bulk of our stakeholder engagement. You start losing people between Thanksgiving and Christmas.
Yeah.
Certainly.
But I think if we can reserve that time to do all the pre-work heading into Thanksgiving, that gives us a month to write the plan, make sure y'all are good with it, have it wrapped up by the end of the year.
And that aligns with your objectives?
Yes.
Thank you.
All right. Thank y'all very much.
Thanks, John.
Appreciate it.
Ode, thank you for your commentary.
Welcome.
I'm assuming you didn't see the.
Right,
I'm John Snow with King of.
right.
Okay.
Yeah, it's a great name.
Yeah, it's right there.
I missed that reference.
His name's John Snow.
And,
Got some more business here?
Actually.
kept on,
It's proud to be a part of it.
Hey, Colbert.
Mhm, he's a great guy. Grew up here.
Thank you, guys.
I tell you what, get you to 2:30 without.
Good afternoon. How are you?
Frankie.
I got the airport, so I had to be home by at least.
Yes,
Yeah.
We also have Anita Byrne here from SSA Consultants, and so that is the second vendor proposal we have today. And so I'll turn it over to you, Anita.
How are you? Good afternoon or good morning. I guess we're technically still in. It's good to see y'all. So as Charlotte mentioned, my name is Anita Byrne. I'm with one of the partners with SSA Consultants. I believe you guys have the proposal in front of y'all, correct? So just to kind of walk through, are y'all comfortable if I sit, everybody can still hear and see? Okay, fantastic. So SSA has a long history of doing strategic planning, and it's one of our favorite pieces to do within our portfolio. It really takes a lot of pride for us to help think about setting organizations in that future casting role, thinking about what does success look like in the future, really thinking about continuous improvement and where are we going when we think about our mission and what we're tasked to do. So our approach is broken into about 4 elements, which is in that kind of main thing on the scope of services. Really start with trying to understand where you are today. I think SSA has had the privilege of working with the Physical Therapy Board across multiple projects and multiple tenures. So have a pretty good feel of the history of the organization, but certainly want to pay attention to that as we get started. What's new? What do we need to learn? I know particularly you guys are tied in with your national association, so understanding what that pattern of life is for you today. Then we'll move into stakeholder planning and input. And so that is definitely conversations with board members. It is conversations with your academic partners, key stakeholders to understand what is the world that you live in today. We do those either in person or virtually, kind of depending on schedules. We know everybody's busy, and there's also an opportunity for us to leverage some electronic communication through surveying, if that's easier for people. But really want to cast that net and help inform the next step, which is what we would come back to to the board and show you what we've learned, right? So from that surveying, from that looking around, what are the key things, and then reflect that back to you as you then engage in a facilitated conversation about, as the board, where are we going? What do we see? And work through that together. We'll then take from the board conversation and kind of do a little bit of the sausage making, if you will, in the background. Work with Charlotte and her team, and kind of then come back to you with the recommendations of the plan. That includes things like timelines, action items for you guys to bless. So that's kind of the 4 key elements. From a timeline perspective, recognizing, we're now in August. You guys don't have a meeting in October. So really kind of the goal would be that by the end of the year, by that December board meeting, you guys are approving your strategic plan as you think about where you're moving into 2027. And so I know I said a whole lot of things walking y'all through it. Any questions that you have, things you'd like to talk about in the proposal? Thoughts, questions?
Do you believe the objective of being able to have a strategic plan developed for the board to consider in December is a realistic timeline?
Yeah, I mean, obviously it's always depending on scheduling, but I think that is pretty reasonable. If y'all are willing to, I'm assuming y'all are going to make a decision relatively quickly at this point. So if we think about kind of a September 1 start, the way it kind of generally would break down is then September and October, we're doing that feedback loop. We're getting things ready. We're going to present to you then probably in November and do a little bit of that before facilitation. We can tack that on. I know you're all coming from different parts of the state and have your own practices and responsibilities. So can work with Charlotte to add that one as a couple of hours to the previously scheduled November meeting, if that works best. But want to reflect that back to you. And then between November and December, we do that finalization, that work through, and bring it back to you in December. Now, if we need to adjust that, I haven't seen your 2027 calendar yet, but if we needed to adjust that, we can. But I think that if we start soon and stay on track, I think that is realistic.
Thank you.
Any other questions?
And so
Yeah.
comment
Yeah.
is, our current strategic plan was developed by SSA, right?
Yes.
Um,
No, the
Second.
current one was developed internally.
I'm sorry, yes, excuse me, right? So my first meeting at the board in person, my first meeting was a Zoom meeting during COVID. My next meeting was a strategic plan session where SSA did. So 6 years ago, SSA put us on this track. 3 years later, we just looked at it and tweaked it and revised it because it was still guiding us. But what we've done is taken the strategic plan and then, so speaking to the importance of the strategic plan, is taking that strategic plan and we've taken a step that's now Charlotte's basic job description. And this is how Charlotte gets measured, is by how she sticks to the strategic plan and the timeline. So having a plan is extremely important, okay? Us having buy-in and guidance to that is extremely important. I will say one of the things that SSA did for us then was make us realize that we have a role as a board in participating in public health policy. Not legislation, that's the advocacy role for the association, but in setting public health policy. And then if we realize that public health policy needs working on, then we then have a legislative role also. And that advice then was, we need somebody to be our legislative director, our public health policy director. Charlotte said she wanted to step up and take on that role. At the time, we thought about maybe there was an additional person we were talking about, because there's both federal and state healthcare policy. In doing that and having a plan, Charlotte stepped up and changed her role, and she then brought in appropriate help beneath her that allowed them to do the administrative work, for her then to step up and take on the role of public policy and outward facing and education and outreach that we're now doing. And that all stemmed from the advice that was given to us by SSA 6 years ago. So we've had a good relationship with SSA.
Thank you. I
Thank
think, when we first, came to the physical therapy board, it was under your previous executive director.
Yes.
And we started with, organizational assessment, and everything from all your licensure information was still on like in-house servers. There was no backup to it. And I was like, oh, there's like one bad electrical surge and all this might go away. And so, I have been really pleased and honored to kind of work through with y'all over the years, from that original organizational assessment, to actually running the executive search that found your current executive director. Had the privilege of facilitating your direct access study resolution, that ended up becoming and changing that legislation as an outcrop, from the study resolution to allow direct access, here in Louisiana. And so, recently kind of worked with the board, I think, about a year ago on a facilitated day. So it's definitely been our pleasure to watch this organization, kind of balance that healthy tension point, right, of the mission of protecting the health of the public, as well as what does good practice look like? What is, good organizational design look like? So it has definitely been our privilege to do that.
Thank you, thank you, thank you. Thank you for your assistance.
Any other questions? I want to be respectful. I know we were scheduled, so I want to make sure I stay on the schedule for you guys. Any other questions? Thoughts? Well, in that case, I will let you get on with y'all's day. I really appreciate the time and the opportunity.
Thank you.
It's always a pleasure to see you all.
Thank you.
Holler if y'all need anything. Well, now.
Okay, thank you for coming there.
Welcome.
Chili.
It's chilly.
Keep you awake.
Says people.
Multi-link.
Okay, next matter is concerning license status of Samuel Forrester involving matters 2024-I-021 and 2025-I-009. Troy, can you please provide us with the update, matter?
Yes, so whenever licensees complete their period of suspension or probation or anything along those lines, we bring the matter before the board for a vote. And so Mr. Forrester's license suspension period is up, and he has completed all requirements of the suspension. And so at this time, we're recommending to move his suspension from his license status to probation. And Mr. Forrester is here if you all would like to ask questions or.
Yes. Okay.
Mr. Chair, for the record, I'd like to, put on the record that I recuse myself from the previous vote on, Mr. Forrester's, complaint, as I have a personal history and needed to recuse myself, so I will continue to be in recusal in these proceedings.
Thank you, Ode. Yeah, any discussion?
Mr. Chairman, with your permission, I would just like to hear from Forrester on what he's learned from his experience with this disciplinary action.
I appreciate that. So, first of all, I've taken 6 months off, and the 6 months has been good for me. I'll step away and reevaluate where I am in my life and career. I'm not someone that purposefully, this was a major oversight on my part, what happened here. I didn't clarify things in my head with billing situation. And it's something that I apologize to the board, and I wish I could redo things and think through more carefully. As a practice owner, I'm not in practice anymore, obviously here, but I don't want to be back in front of you guys. I know you guys are all professional. I appreciate what you do. But I would like to get my career back going again, so I can get to where Ode is and keep on working for a while here. Worked for Ode in the past, and so in any case, I want to do what's right, and I will definitely take my time thoroughly to clarify any issues that if there's a gray area or if I have questions about, not rely on somebody that's not an expert or doesn't know. So I think that's it.
You set up things for the future to allow for any type of confusion or clarity.
As far as job work, I don't have anything right now. I'm waiting to see how this all came out before I did that. I didn't want to jump into something or get any kind of business owner. I'm not going to work for myself. I hope to join up with some company, hospital, nursing home, rehab center in some capacity as an employee. And that's where I'm at. I guess the only question I have is in the orders. It says that I am supposed to have any tech or PTA sign off on read the orders and sign off on it. And if I'm in a facility that has multiple techs or PTAs or part-time in and out, or I don't know how that should be handled. So that's really my only question there.
Carla, can you provide guidance? You know, that question?
So are you referring to item 6 that says during the 2-year probationary period, respondent shall provide a copy of this consent order to his employers, direct supervisors, and any physical therapist assistant, or physical therapy techs who are supervised by, work for, or contract with respondent at any business, including but not limited to any businesses that the respondent owns, operates, or manages before providing physical therapy services, and shall have such persons notify the executive director in writing that he or she has received and reviewed a copy of this consent order prior to respondent providing physical therapy services. And respondent shall do this Also, with any new or subsequent employer, direct supervisor, physical therapist assistant, or physical therapy techs during the probationary period. That's,
Yes.
yeah, so, your question is, would it have to be all of them?
I mean, if somebody is, if I'm in a hospital environment and I have PTAs, obviously, I don't have a problem with that. I understand that. A tech who's potentially in and out, may not be a regular employee or a daily employee. I mean, they're coming in to work with me for, a couple of days a week. And I don't know how to handle. I mean, the first time I see somebody working for me, do I have to lay that down and sign off on it? And I may never see them again. I don't know. And I'm just, that's the gamut of the question that I have, the detailed part of it. So
Can you speak to how other employers have handled this?
Sure. So other respondents have provided it in writing when they follow that. I don't know that any exceptions have been made, but should you have some sort of unusual situation, then you would have guidance from the board to make sure it's satisfactory. But the way that it reads, it sounds like, you have so many individuals that you would be supervising, and those individuals would need to sign it before you could deliver any physical therapy services the way that it's written.
If they're here, if they're there to assist with your plan of care, to assist with the PTA that you're supervising, or assist with you, whatever capacity that you're talking about in general, and they're under your care, and they would fall into that criteria. They may have some, maybe within the hospital, whatever it is, that work with, other PTs or whatever that may be. And I understand that some staffs are large, but if they're under your direct supervision, I think they would fall under that category.
all right.
If you're working in a department, the department hires, and you can always get your supervisor, department head to assist you in making sure that any and all new hire gets the consent. It's more about accountability, making sure that they understand that there was an issue before from a billing standpoint, supervising standpoint, that they're not going to sign off on, or,
All right.
It's part of our due diligence, part of our due diligence to make sure that we're putting that out there. There's nobody under your watch that doesn't really know, the history. And not that we're trying to just like tell everybody business, but we can't just work on trying to make you as comfortable as possible and not be able to share stuff. We have to still protect the public instance. So that's why it's in there for that. So they have to be known aware that of what you're going through during this period, right? This is not showing for life during this period while everything's going back out there, going back to normal, going back to work. And we're just entrusting that everything that we put in place thus far has worked. Right, so if we allow for a probationary period to allow for us to assist with monitoring, stuff like that, so that we're not just releasing or making sure that we're putting people out there. Not saying that you're not, but I know you from here, right? And so
Right.
Same as everyone else.
Yeah.
Know you from here. That's just part of the process.
All right.
So I do have some clarification from the Practice Act position is that, again, if you're the PT, and you see a patient, you become the PT of record. You become the supervising PT of record. There may be a PTA that comes in on the weekend that you don't know about. You've never seen them. You'll never see them. But they need to know and have your history and have your record because you're supervising them. And everybody just needs to be aware of the history. So,
How does he get that PTA to know that?
well, I think some of this is going to be his employer.
Yeah.
And his supervisor understand that they're taking on this responsibility too, that he's coming to work for them under probation, that it's their responsibility as well as his to make sure that everybody understands, because everybody needs to be aware of the situation and have their eyes on.
I agree with O'Day.
So it's everybody.
There is the
No
employer, the employer who hired you during this probationary period. They are, responsible to make sure that this order, is being followed, and that, everyone who's on your team has had the ability to review the consent order. And then, all the members of your team can sign some type of document, something in writing, and indicate they have received and reviewed it, and then that would be presented to the executive director. But your employer, I would
Yeah,
encourage
yeah.
you to have an employer assist.
Yeah.
During this.
Assist in the oversight of that.
Yes, assist
Yeah,
in the
yeah.
oversight during your probationary period to make sure that, that the terms of the consent order during the probationary period, are being adhered to, so that you are not subject to future disciplinary action for violation of, your probation. The terms of your probation.
All right. You need schedule to take those courses 6 months.
I have actually completed those.
Yeah.
Yes.
You know, I've been in front of the board and I know how scary it is, and I know that, in your mind, you're not gonna do this again, you're gonna be on the straight and narrow, so this is not meant to be anything against you, your character, or what's gonna happen in the future. It's more about accountability. If I can take the position of a physical therapist, as a physical therapist, we carry a lot of weight, and some physical therapists do abuse that power in fudging a couple of different things, and the subordinates will just go, my physical therapist said. So
Yep.
it's, the consent order is there, again, going back to the words that I used, as an accountability to the duties that you have towards the clientele that you're taking care of and your employer, because there definitely is some liabilities to your employer if you're working for somebody else.
Yep,
Thank you.
I understand. Thank you.
Thank you, Mr. Morrison.
All right, thank you.
Any more questions or discussions?
Mr. Chairman, in the matter of Samuel Forrester, consent order number 2024I021 and 2025I009. I move that we change the status of this individual from his license status from suspension to probation, as indicated in the consent order.
And I'll second the motion. That's written.
All in favor?
Aye.
Roll call.
Roll call. Public comment? Let's take a roll call.
Okay, Danny Louis,
Yes. in favor.
Madam Chairman, well, upon reference, would you please call on the chair to vote last?
yes, thank you.
Because the
Odette.
chair has the right not to vote and to vote to break a tie. So if you would, please call on the chair to
Thank you.
vote last.
Thank you. Claude Tremblay,
Yes.
Ben Gaines,
Yes.
Lee Riley,
Yes.
Adam York,
Yes.
Michael Hildebrand, and O'Day Vernon.
Abstain.
Okay, the ayes have it.
Well,
Thanks, Sam.
All right, thank you.
Thank you.
All right.
Right. Do we have another consent order that we have to review? We're gonna do that after.
Do we have?
This is it? That's that we'll do that in executive
Yeah.
session.
I didn't have the, was it Forrest?
But I don't know that the agenda was amended for the other. I think we need to go back into the.
It's on the agenda, it's under item 10 rules.
I thought we took him back up,
We bumped him.
not the whole section.
We'll go back to the rules and then we'll discuss the voting of SSC and merchant.
Okay, so on the rules, I believe we stopped at physical therapy technician. And so, just resuming from where we left off, we are at plan of care. So plan of care is amended to remove the words and incorporating documentation standards in 341, which are being amended. And to add plan of care is considered synonymous with treatment plan or treatment program for the physical therapy patient, which are used throughout the Practice Act handbooks. Next item, adding the definition of Practice Act, to clarify that it's the Louisiana Physical Therapy Practice Act and the statutes. Next, deleting practice of physical therapy as defined in statute. Because it references the statute. Next, progress note, it had just referenced documentation standards, so we are scratching that. And just to note, there is not clarification on what the progress note would be.
Charlotte, I'm gonna suggest to the group that it'll come back later, but that we put a pin in preventative services. Because we're gonna need to have a clarity on preventative services and wellness services, whether it's treatment or it's not treatment, whether you have to document and what kind of supervision goes there, because what is preventative and wellness today is absolutely 100% not what preventative and wellness was when we created the term and placed it in the Practice Act. So the world has changed, and I'm going to suggest that we take a look and make sure that we modernize it.
Would you like me to put any note on the document that gets uploaded for the public to view?
I maybe just make a note that, you know, for further discussion and open a comment.
I'd also like to have some further discussion, possible, not now, but another time.
If you could speak up a little.
I'd also like to have some additional conversations on the definition or the understanding of and need of progress. Because between different settings, not the definition, but the requirements that we have and the standards that we have between different settings, just because I see at different settings how it's utilized. And the idea of progress note, progress being reported within an encounter note or in a weekly stance is one thing, but like let's say this example, CMS guidelines, every 10th visit or 30 days, whatever happens first, okay? And so in a SNF setting, you have a progress note that's generated by standards of the documentation standards only for physical therapy services. Occupational therapy and speech therapy follow CMS guidelines, physical therapy services weekly. Well, you have patients that are on programs that are one session per week. So you're doing this lengthy 6, 7, 8 page note that is required every week on somebody who has one note that week. And so
Are you proposing for us to have a definition of what a progress note is?
no, I think the progress note is
Because,
reporting.
you know, just as a point of clarity, today we're dealing with definition.
Correct.
And then at a subsequent section, or, you know, when we review subsequent section, that's when we're gonna have more of the meat and potato of the administration of, or the practical aspect of. So I think to the point of the definition, scratching is fine. And then when we discuss progress note, you know, maybe have some wording as to setting requirement or insurance-based requirements.
Yeah, it just came up whenever I saw it and just thinking about it, maybe for a later conversation.
Yeah.
Yes.
That's all.
Yeah, that's awesome. I agree.
Mr. Chair, in the interest of promoting discussion from public comment, what are we going to put as a note under the definition of preventative services? What are we recommending? Because we want to promote public comment. We want to get comments from the public about this. If we don't change the definition in any way, how will we promote public comment?
Based on the note, what I was going to put, and you all can tell me if this is not what you want, I was gonna put, further discussion is needed on the definition of preventative services to determine if it needs to be amended to modernize the definition moving forward. Public comment is requested.
When
And
I
that's
look
not
at the definition as it's written, using skills from a physical therapist, for me, that equates to treatments, not preventative care. If I have somebody that comes in and asks for a knowledge, just wants me to kind of supervise that their technique is proper or whatever, you know, or if they are under my umbrella, but as a healthy individual coming in and making sure that everything is kosher, I don't think that requires us to define it as a rule for physical therapy, more so than acknowledging that those are not requiring skills.
Yeah, Lee, what was part of your comment on some of the rules? Did it pertain to this statement that this does not include the administration of physical therapy? But then when we look at the definition of physical therapy, it's all of those things that we do. If you do an assessment, you use your knowledge, you use your skills, you do consultation, all of those things are the practice of physical therapy.
I think that the promotion of health and wellness, the optimization of function, and the enhancement of human performance are all under the scope of physical therapy practice.
Yes.
Those are all services that physical therapists can provide.
Yes.
When you provide education, when you provide advice, when you provide services, when you use your knowledge, expertise, you know, and training to provide education with the goal of preventing disease, preventing dysfunction, optimizing health, or enhancing human performance, that is treatment. And so my recommendation would be to scratch from the definition, this does not include the administration of physical therapy treatment.
Correct.
So that would be my recommendation to how we change the definition.
Yeah.
Just scratch that.
So the history of why this is there is when we were making baby steps towards direct access, there were certain things that we said that we could do without a referral or a prescription. And one of them was to promote wellness,
Right.
to prevent injury. You don't need a prescription. You don't need a referral. You don't need a diagnosis for that. Okay. And that was one of the things that we could do without a referral. Right. And then we brought in the word wellness. So I'll throw the same caveat when we get to wellness, is let's redefine what wellness is. Because then it was at the end of your care, you could continue to see your patient if their referral expired and they wanted to continue to stay fit. The other one was, again, it was a circumvention for needing a referral, is that they're coming for stress relief, they're coming for wellness, they're coming for prevention, we don't need a referral for that, okay? So now that we don't need a referral for anything, now we need to modernize what those words mean, because that was just a way to circumvent the rule at the time, the statute at the time. And we circumvented it in the statute. Okay, so we didn't get around it. We just added little baby steps to get to where it is we need to be. Now that we've gotten where we need, we've not gone back in and just taken all of those things out, which is what the board attempted to do about 4 years ago, was to just clean up all the old redundant issues. Because it does cause confusion, as this is, okay? And so I'm going to suggest that preventative services, wellness, client, patient, anything we do as a physical therapist is physical therapy
That would be great.
at all times.
So is a definition of preventative services needed?
That was my point. If you're looking at preventative service without a pathology, then do you need a physical therapist which deals with and uses knowledge and skills to rehabilitate, not to habilitate? Anybody can perform preventative service. An athletic trainer can come in and use their knowledge, their skills, come in and assist with the prevention of future injuries. A chiropractor can do that. A nurse can decide that they are in the wellness and anti-aging spectrum of, so again, from a definition standpoint, if you are providing treatments, that's one thing, but the treatment needs to be associated with a pathology. Prevention services is too great for me.
Mr. Chairman, what I would suggest is the statutory definition of the practice of physical therapy includes the use of the physical therapy services for prevention, therapeutic, or medical purposes. It's in the statutory definition that preventative services is part of physical therapy practice. It is recognized by the American Physical Therapy Association that the promotion and the prevention of disease, promotion of health, optimization of human function, and the enhancement of human performance are all within the scope of physical therapy practice. So if in the interest of avoiding confusion, we could strike the entire definition of preventative services, because under statutory language, it's already under the scope of physical therapy practice.
I would agree to that.
I'll scratch it.
Okay.
Yeah.
Okay, so for the purpose of posting this on the website for public comment and discussion, we will strike preventative services.
Correct.
And in commentary, we will put.
And by striking the whole thing, it then eliminates the next level of confusion is in the wellness setting. Okay,
Uh-huh, uh-huh.
you can do preventative services and not be in a wellness setting.
Yeah.
And what is a wellness setting?
A wellness setting is a practice environment.
Yes, correct.
So I mean, whether
It could be at the gym though.
it's, if you're at a commercial fitness center and you're a physical therapist practicing in a commercial fitness center, and that is a practice
Yes.
setting. What you are doing is you're practicing physical therapy
All the time.
Right.
at all times.
Sorry, the statute already.
There's a statutory definition of practice of physical therapy.
Okay. Moving on.
Okay, Adam, were we finished with your comments
Oh, yeah.
about progress?
Yeah, I just saw it and I wanted to put a note on it to be able to open up discussion in a later time.
Are we recommending that we include a definition to be less confusing or just leave it the way it is for the public comment? Okay, when we review documentation standards, we'll consider it, okay. Okay, provisional license is the next definition. So we're removing the third type of provisional license applicant, and so we're changing the word from 3 to 2. Also, in the first type, a CAPT graduate pending examination, it says it's an applicant pending the results of a fixed date examination, but in rule, it says that you have to have the exam scheduled in the 90 days. So if you had already taken the exam and you were just pending results, those two rules are conflicting. So we have to pick one or the other. Do you want to be able to issue provisional licenses to people who have taken the exam and are waiting for the scores? Or just for those who have, are scheduled to take the exam? Because they might, it's more of an administrative burden to give them a provisional license and then, if they've taken the exam and they're just waiting for the score in a few days. But,
For me, it would be scheduled because they graduated from a CAPT program and they are just waiting for the license, which is an administrative demonstration of their administrative understanding more than their clinical proficiency and knowledge. So the program itself, graduating from it, has shown all of those teachers that you were knowledgeable, proficient, you did your internship, you've been signed off as safe and knowledge enough in terms of pathology and treatments. So graduating from the program does not preclude you from starting if you have a scheduled date for, rather than waiting for the results of just taken another exam, and if at the end of those 90 days or at the time of their exam, they showed that they were not able to pass the exam, then obviously at that point, it's no longer a scheduled thing, but the fact that they haven't passed their license.
So just point of clarification. Because the rule, later in the rule, the way that we issue provisional licenses says that they have to schedule the exam within the 90 days of the provisional license. That's how operationally it occurs. Okay. This definition sort of conflicts with it in Part A because it says they're waiting on the results of the exam instead of they're waiting to take the exam. If an individual takes the exam and fails it, they are eligible for a provisional license as long as they have the exam scheduled within the 90 days, even if they fail the exam.
Sure.
They can only have one provisional license. So, just wanted to make sure
So-
everyone's aware of that.
From a function standpoint, I'm agreeing to that.
Okay,
Again, if the licensee graduates in May, decides I'm not applying for my temporary license till October, right? Then at that point, they have 90 days. Or if they choose of their own to wait for their exam, then at that point, it's no longer about the result, it's still about the 90 days.
Charlotte, you said if someone fails the exam, they can get a provisional license to the next exam.
yes,
They can only get that one time.
you can only get it one time.
If you fail the exam a second time, then what happens?
So in terms of the provisional license, you can only have one provisional license and you can only have it for 90 days. You can't renew it and you can't get a second one, the way that that rule reads.
Is that what we wanted to read?
That's,
If we fail it again, I guess you no longer have a license, provisional license, right? You gotta wait another.
So you go sit at home and wait till the next exam session.
Or you work as a tech?
you can take we don't think
Yeah.
we've ever had this, but you could take the exam twice and then decide to apply for a provisional license. The point is you can only get one provisional license.
Yeah.
We don't say you're only,
90 days.
90 days.
and it's only valid for 90 days. We don't say when, how many exam attempts. You know, I would think that if you had 6 attempts to the exam, which is the limit, and you apply for a provisional license, that would probably have to come before the board for approval. But we haven't had that occur. So we don't have a number in rules to let us know what to do. So that'll be discussed at the next rule, next group of rules. Okay, so we're all clear on that? Okay, PT, see physical therapist, PTA, see physical therapist assistant, reassessment or reevaluation, see documentation standard are all proposed to be scratched. The definition of student. So we are scratching the word certified and adding the word accredited before CAPT because it's accrediting agency, not a certifying agency. And then we're scratching the word and putting or instead, so that if you are a person pursuing or in a CAPT program or a program approved by the board, not and. So if you're in a program that's not CAPT accredited, you could be considered a student. And those are the changes.
Public comment.
Yeah, that was a few meetings back. There was a gentleman that.
But there was somebody else in the.
There were, yeah, Mr. Chairman, there was a public comment regarding this, regarding the standards by which the board makes the determination to be a board-approved professional educational program. Now, we already have standards under the rules regarding foreign trained physical therapists. Are those the standards that we are proposing to apply to any other program if we do change the definition of a student? Because those standards seem to apply to someone who's graduated from a accredited program in their country and are coming to here to practice. And then there are rules that to govern the licensure of those individuals. Are those same, how are we going to negotiate approval?
So we have rules for foreign program. The way I understood was, let's say the Monroe program has not received their CAPT accreditation, right? And they graduate their first cohort. Monroe's program has not passed CAPT, but they're able to provide to the board a curriculum that matches from a university that has track record, right? And it wasn't invented 2 weeks before the program was slated to start, right? So if they have a good biology background, anatomy background, and all that stuff, and they're just waiting for the CAPTIA accreditation, do we need to prevent those students from be considered students and do internships or rotations with PTs and be considered students just because they haven't received their accreditation? Like I said, we have rules for foreign. Now we need to kind of establish, in my opinion, a rule for local. And having an or allows the student making a plea to the board saying, I want to be considered a student so I can be supervised by the physical therapist as a student rather than being in limbo up until my program gets accredited.
What they, is them?
Yes, so it's also the same concept that we say, when we chose to insert for testing, when we said the NPTE, and then we said or board approved examination. And we didn't write the qualifications for what a board approved examination would be yet, okay? Do we need to do that? What we're trying to do is to say, if there ever is another organization that competes with CAPTI, can we use them or are we locked into CAPTI? If there ever is another national licensing exam other than NPTE, can we do that and leave ourselves that window open? I don't think that it requires us right now to say what a new exam would look like for us to approve it, or what a new school would look like if we approve it. Plus, I do think that we have the authority in testing that we could give someone a test to test their clinical skills and make them perform clinical skills and do an oral exam in front of the board members if they chose to, if they fail the test 6 times and someone says, this person is a good therapist, I've seen them work clinically, we then could come up with a test. No, we don't have one.
Yeah, but the
Okay.
or allows us.
The or allows us.
We shouldn't allow and give a monopoly to CAPTI or NPTE.
Right.
We
Yeah.
should reserve the right to establish if we have qualified applicants and that or is there. But as
Yeah, so the
Odin
question that
pointed out,
comes from
we
the
don't
public-
have a structure currently.
Do we need to have the rules and regs for an alternative test, alternative accreditation right now?
No, but this would allow, the or approved by the board would allow a student who's in an exchange program to be able to come and do a clinical exchange.
That's what this was brought to our attention by,
Yeah, let's not say who, let's
yes,
not reference.
right?
Yeah.
But I do know there are 2 definitive programs. One's in Louisiana, one's not in Louisiana, and they have either branch campuses in foreign country, or they have an affiliation with a sister school where they let their students do foreign exchange. And right now, if they came from, some country that school's not CAPTI accredited, then they may not be able to get the credit hours for doing their affiliation in America, or vice versa.
Or they wouldn't be able to act as a student.
Right.
They would have
Yes,
to
yes.
act differently. As like a tech,
Which is different,
which if you want them to be.
Changes the
You can-
interventional capacity of that.
not getting the education
person.
component of that.
Thank you.
So no changes to that.
We can entertain public comment.
Wonderful. Okay, supervision as proposed here is now struck through on mine, so we'll just delete that from the next version and not have a supervision definition. Supportive personnel is added. It's used in statute, but not in rule.
So, Mr. Chairman, so that change, so the Supported personnel was in the last legislative changes to the Practice Act, right? And the term supported personnel in statute 2418 F2 A specifically falls underneath the statutes governing the supervision of physical therapy assistants. It makes no reference in the statute to unlicensed personnel. So I think it's problematic for us to include a definition of supportive personnel, adding unlicensed personnel to the definition of supportive personnel when the statutory use of supportive personnel falls under the statute related to the supervision of physical therapy assistance. So to that extent, if we were to define supportive personnel as physical therapy assistants, we don't have to include unlicensed staff who meet that definition. It would not preclude physical therapists from using unlicensed staff in their practice. It just would give clarity to who supportive personnel is referring to from a statutory standpoint.
During the new modifications, what does it reflect to supportive personnel?
You are allowed to supervise up to 6. A physical therapist can determine the number of supportive personnel that they can safely and confidently supervise.
And if you remove it and to say unlicensed this definition, that would just be
You could have 6 physical therapy assistants.
right. And then there's nothing.
You could have an unlimited number of techs.
Gotcha.
There's no statutory limit to
Right.
how many
That's what I want to add.
administrative staff you can have. There's no statutory limit to how many, techs you can have. At this point, the statute doesn't say how many limits you can have to unlicensed personnel who are working in your business.
So you're saying we got 6 PTAs?
I think my recommendation would be to provide clarity.
Yeah.
And not to add unlicensed personnel to the definition unless that was the legislative intent. The legislative intent was to include unlicensed personnel underneath the definition of supportive personnel. And from the statute, it's not clear to me that that was the legislative intent.
We say take this unlicensed personnel out of the word personnel.
Yeah. The proposed definition that I would recommend the board consider.
I agree with you.
Is. Yes,
If we did that, if it says supportive personnel and we consider supportive personnel to only be
License.
licensed, then that means that's 6.
Right.
Okay? If we don't include that, the unlicensed supportive personnel in that ratio, and I choose to practice and have no PTAs, I could have a dozen
Right.
unlicensed supportive personnel helping me carry out my care.
Mhm.
If
we further define that there is general supervision and there is direct supervision. So the idea is the direct supervision, unlicensed personnel would fall under direct supervision.
we just have a lot of moving parts, and I'm just gonna caution us that as we do the moving parts, that when we all come back, we recognize that the original legislative intent was not to eliminate physical therapists from using unlicensed supportive personnel to help them carry out any portion of the treatment that they so choose to assign to them.
Yeah, it's the professional judgment of the physical
Yeah.
therapist, but it's within
You would
a
change.
certain
definition.
parameter of treatments that are for unlicensed that do not fall under license. So a PTA can do joint mobilization, passive range of motion, different things of that nature. Whereas a tech can supervise somebody that at the discretion of the physical therapist
In-
doesn't require.
In theory, if I taught my tech how to manipulate, and I said they were safe, then they can manipulate.
Yeah, but that's outside the scope of an unlicensed
Is it?
personnel, in my opinion.
Is it? Is it? Because it
That's
says,
My opinion.
that's correct. It says whatever it is I deem that they're capable and safe to do, and they're trained, and I put it in their personnel file. I'm not suggesting that.
Yeah.
I'm just trying to.
Then what you should propose is a definition of what unlicensed is and limit their capacity to unskilled and
I think you're getting in dangerous territory there.
Leave that definition.
things that doesn't require you going to get
Yeah.
an actual degree in license.
Go ahead, Lee.
Mr. Chairman, there will be a discussion as we move forward, where we can further define the supervisory requirements and the provisions of the physical therapy plan of care that unlicensed personnel can assist in, right? That's for a further discussion. Related to supportive personnel, what I would pose for the board to consider is that the definition of supportive personnel is an individual licensed to practice physical therapy pursuant to this chapter who is delegated one or more provisions of the physical therapy plan of care of a patient or client by the supervising physical therapist of record.
Where's that from?
That's the definition proposed.
You're just removing unlicensed.
Unlicensed.
You're licensed physical therapy of record. And the back end of it.
It's just clear because it's clarifying because that supportive personnel term is under the statutory language for the supervision of physical therapy assistance. I think it hamstrings businesses if you include unlicensed personnel in that six. If you consider them supportive personnel, you're limiting businesses to only being able to hire 6 individuals in assisting in the execution of a physical therapy plan of care. Okay. I don't think that's a legislative intent to limit the business's ability to hire individuals.
Correct.
But we do need to have clarity, in terms of who that relates to. And so my recommendation is that relates to individuals licensed to practice physical therapy pursuant to this chapter.
I can agree with that. I think that you have a lot of clinics that have a lot of people that do a lot of tasks. And sometimes people working doing medical billings, people working this, and they supported personnel, what's not. And then you eat up those. We have people that
Yeah.
transfer patients back and forth, and they're not really checking.
What is
But now
that?
they're eating up those numbers. I agree. I
We
think
all- we
I think
agree
it's a
to
good
delete that.
change. I would agree with that.
I agree with that.
As long as by leaving them out, then we're not saying that they can do it by exclusion.
Yes.
There has to be somewhere in there that still says
Say-
that you can use them.
Yeah.
Okay? Because there are some states that are just silent on it. There are other states that prohibit it. And then there are states like us that allow it, and then we count them in the head count. I'd be tickled pink if we take them out the head count and still use them as we see fit.
And I think that's a discussion that we can have moving
Yes.
forward.
Yes.
I don't think, as I said, I don't think it's a legislative intent to limit the number of individuals that a physical therapist can hire to help them execute plans of care for citizens in Louisiana.
I agree with you, Andy. Some kind of statement also.
Yeah. I like where the conversation's headed.
Okay,
Well, and we do define physical therapy tech still, so it's not like we completely scratched the definition,
Correct.
so.
right.
Technician. So, yep. Oh,
You need public comment?
I agree with striking unlicensed.
okay, so the next definition is treatment plan or program. And we added the sentence, treatment plan or program, or treatment program is considered synonymous with the plan of care for physical therapy patients, which is, the same language we added to plan of care. Because they're used interchangeably throughout. Unless y'all disagree that they should be. And I will note that in the old language for direct access, where it says, a child with developmental disabilities pursuant to their plan of care, those plans of cares are specific in the statute. And whenever I was reading it, reviewing all of this, I was thinking that is the physical therapy plan of care, right? And so, because the only thing would be like if we wanted to define how plan of care is being used there compared to how, the physical therapist.
It
treatment
is,
plan-
but it isn't. The plan of care with the student is they call it the IEP, the individual educational plan. So it has to do more than just with physical therapy treatment. It could be all day long positioning, it could be all sorts of things. But again, we go back to PTs who are working in the school systems. PTs in the school systems was mandated by federal law. And that federal law says that, you know, the teacher and the guidance counselor and everybody gets together and they come up with a plan. And then they hire people to implement the plan. And the mandate was to hire physical therapists in the school system to carry out these plans. And then it was like, well, you can't go do it unless you get a referral.
So in that same statute, it would be, you know, a patient in a nursing home pursuant to their plan of care, a patient in home health pursuant to their plan of care. So if those plans of cares aren't synonymous with treatment plan or plan of care elsewhere, then that they're being used synonymously would maybe not apply to the definition of plan of care if y'all wanted to define plan of care specific to those situations in statute where they use pursuant to their plan of care in those specific situations. Or if y'all think it's just, you know, much of the same, then that's just something I noted whenever I was going through that those plans of care might be different.
Again, and those instances were, when can you give treatment without a physician referral?
Pursuant to their
Directly
plan
to
of
the
care.
PT. And so, again, it was a workaround for having access to patients without a referral.
Do
So when
you,
the nursing home and the house doctor said they need PT, well, you know, you did PT. That was their plan of care. Was that a referral? We use it that way, okay? And so in all of those situations in the school system, all of those were just ways to get around having to have a referral. Now that we don't have to, they're still in the Practice Act. So now it gets confusing.
Well, let me ask you this. A plan of care can be a treatment plan, but a treatment plan cannot be a plan of care. Meaning, if the plan of care for that particular individual is PTOT speech, that's the plan of care, and the treatment plan specific to PT is a treatment plan.
Yes.
Good question on the daily treatment record. It says it could be in a daily note, form of a checklist, flow sheet, or narrative. So a daily
Yes.
note can just be a checklist without having a narrative written, like a soap note.
so that's the next definition. That language came directly from documentation standards, Rule 341 that we scratched. Just copy and pasted it and put it back there.
Okay.
And the reason why is that if we're, and we can discuss this at documentation standards if you want as well, but with the EMR, there's different language that's used on the title sheets. So it might be like progress note, it might be this and that. And a lot of PTs do use that sort of like checklist every day, and then they do a larger progress note. But the concern was if we scratched that from documentation standards, it could be that people don't believe that they could still follow those standards of practice, where they're just, you know, there is such thing as a treatment record that you can just, you know, use between progress notes.
Just trying to clarify this in my head. So you're meaning that a daily visit, if nothing changes, we're not bound to a soap note, but we can use a narrative.
That's my question.
But that as a recap, let's say of a week or a treatment plan, then you are bound by the SOAP note establishing what the assessment of the progress of all of those narratives are. Is that what you're?
So there is a little bit of the rule language left out. And so it says, you know, the way that it was before, and I don't have 341 in front of me, but it says, you know, the documentation of a patient visit when a more detailed progress record is, oh no, it says it differently, actually. It says, let me read it to y'all.
Amanda, we're in the public. So I think this has always been confusing. Like, I know you have to look at it. On it, but it is confusing to many, like, this is what here too. So the daily note, yes, you could just check off. You can do that in any format. I'm not sure that any part of our documentation standards says it must be in a SOAP note format. I don't know that. But for the daily note, you can just check something off. It could be extremely minimal if wanted according to what our rules say. However, what typically a therapist thinks of a progress note is the 30-day progress note. And because but the components of a progress note is that you are, like we tell our employees, you must measure, you have to have objective measurements, you have to reflect on the goals and comment either progression towards or regression from the established goals. And I think that's kind of it, like provides.
In the logistics, at least for me, a progress note is if something has changed in the status of the patient, a full reevaluation is what you just described, where you're changing goals, and unless something changes,
So then we go on in our rules to say a reassessment or reevaluation. So what I'm saying in practice, most people think of a progress note as every 30 days I'm required to do a progress note. But the way I interpret it, it's confusing, but we do weekly notes. Now we always do SOAP notes, but technically it could be a checkoff, right, on the daily note. Then on the weekly, you must take a measurement and you must comment on the goals on the weekly note. And that's what I interpret the board to call a progress note.
Lee, you have the definition of progress note? The documentation standards, progress note to be reported. It says on us, says
Weekly.
Weekly. So that's what I'm saying.
Not 30 days.
I know that. What I'm saying is in practice, when you graduate from school here and you've been on clinical rotation, maybe this RCIs didn't know this at the time, I don't know, but when they come out, everyone thinks of progress note. When you got a Medicare 10th visit progress note, what we came out in practicing was we think a progress note is 30 days. What the board defines or calls a progress note is a weekly note, right? But a weekly note is different than a 30-day progress note or.
Correct.
And it's also different than a reevaluation. You bill a reevaluation, right? If there's.
Yeah.
So I'm just saying it's confusing the way we have it written. But it's specific, but weekly you must take objective measurements. Daily you do not. That's the difference between daily note check off.
I think this right here is trying to determine like a minimum documentation standards. Is that kind of what this is? Minimum documentation.
Does it not say somewhere that before a physical therapist treats a patient, you should reassess your patient and determine the outcome of the previous treatment before you begin treatment today? Because a long time ago when that was thrown in, that was because people would go to the clinic and they'd start just what they did yesterday, and PTA or the techs would just get them going, and then at the end of the treatment, then the PT sees them. Well, now it's the PT should see and assess the patient before each treatment begins.
So in Rule 345, unprofessional conduct, B1B says, failing to assess a patient's status at every visit. So it's unprofessional not to do that.
Yes.
Is that what you mean?
Yes.
Okay, so from a definition standpoint, if Amanda and I have different understanding of what a daily note, a progress note, a reassessment,
Yes.
or a reevaluation is, or an evaluation, do we need to have words that define more clearly what those things are?
So, yeah.
I think the public in general have a broad understanding, and have people tell me all the time, asking me like, what is this supposed to be? What is this supposed to be? Definition of a progress, the weekly progress could be reported in a daily note, documenting the progress for that being attained that week, not necessarily a full, what they consider progress on a document, which is a 6-page document in our sense.
Yeah, which is a
Right.
reassessment or a
Right.
reevaluation.
Correct. And so it doesn't necessarily need to be that, but that's just their interpretation all across the board, so.
The confusion comes because we have our definitions that probably are archaic, okay, that define what we did and how we documented it, which is completely different than the documentation requirements required for you to collect your reimbursement. The progress note that you need for Medicare has nothing to do with the progress note that you write at the end of the day when you see and document your patient's progress. Now, do we need to redefine all of these? And if we do, is the definition about the practice of therapy or about the reimbursement of therapy. Because we cannot get in the business of writing our rules and our law
But-
to make Medicare cross happen.
But let me just throw that in and put Medicare to the side. If you have a clinician that believes that a 30-day reevaluation is and can be charged with the reevaluation code, then there's a billing issue. So having better definition of what a daily note is,
Yeah.
can't charge a reevaluation for that. Weekly reassessment or progress note, and a 30-day reevaluation, all of those different terms would definitely prevent patients from being charged, insurance company from being charged inappropriately, and physical therapists getting in trouble because of billing practices that are not within the definition, or they misinterpreted what the definition is. So if somebody can tell me that my daily note, if the patient comes in, I do a quick reassessment, you're doing good, how'd you do with the last treatment and all that stuff, and I can put just a little narrative without having to do a measurement because the patient is doing well, at the end of the week, do a progress note that includes a little bit more meat to the bone, but without having the 6-page, garbage, and then after a certain period, doing a reevaluation. Of the reevaluation is when the patient is put on a hiatus for a little while to see if they're continuing to progress by themselves without being discharged from the last, whatever. So I think that if I'm having confusion 31 years in and having some definition differences, and there is transgressions that we have with documentation that leads to PTs being disciplined, then I would propose that we have better definition of what a daily note is, what a progress note is, what a reevaluation is.
Okay, so because it is defined right now in Rule 341, and the Practice Act Committee is proposing to scratch that. When we get to Rule 341 in 2 more cycles, we'll look at that. We can move those definitions to definitions if, like, whenever we were going through progress note, we were like, okay, we're scratching that, but we're not adding a definition. Same thing with discharge summary, same thing with patient care conference, same thing with treatment note, it was left in here. Or moved into here. I will say that one of the confusing things that I've heard from the licensees is that whenever they look at the records in the EMR, the titles in the EMR don't match up with our titles. So even if we define it in here, I don't think that that's necessarily going to fix the problem, because different EMRs use different terms, like
Sure.
progress
But
note is different than what.
If there is a complaint, then we have a standard of what those things should be.
What they should be, yes.
Right? So if the title of my EMR for my daily note or my daily visit is progress note, then you look at it, you look at the timeline, and it's like, not a
So
progress note,
If
so you're
we,
fine.
if we get a complaint in and it's heavily documentation based, and we want to say like, okay, we're looking for certain things and we need to have it supported in the Practice Act,
Mhm.
that these things need to exist, and this is what they are by definition, whatever you call them. Then we do need, because in the proposed rules, it's all scratched. So we need to re-add those to the definitions maybe, or to back to 341.
I think just establishing minimum documentation standards is, like a baseline. Whatever CMS requires, what CMS requires, you gotta have to fill it out based on there. With us, we still just have our minimum of what is required through the board
But,
to regulate.
but
And
to,
those
to,
are separate, but
yeah.
they're still minimum. right?
but to Charlotte's point, do we need to have the definition in the definition to clarify it for the clinician in their mental, I never thought about a flow sheet or a narrative and a checklist and all that stuff, because I am a documentation neurotic person, and you can ask my staff and they say, those notes are just ridiculous. Even though I use some shortcuts in certain things, I'm pretty exhaustive in the stuff that I put down, and anything that changes even minutely, I make a point to document. So this doesn't really bother me as far as definition is
Right.
I think
concerned.
some clarity.
But I'm going back to my point of the fact that we have people that get disciplined for billing and documentation that don't match. So if we have somebody that
Yeah.
comes in and gets disciplined, then I need to know, is it a daily note that can be just a little narrative?
Okay.
Patient did well with the last treatment, no new complaints, continue on.
Well, it says here, flow sheet, check out.
Yeah,
Not even-
in the new wording, but is that a daily? Is that a progress? Is that a reassessment?
Okay, so I think I've got to make this clear. What I was trying to express is with the way it's currently written, it causes confusion and I'm sure leads to disciplinary action. And makes it difficult to practice here. But in our previous discussions, many discussions at looking at this, I believe one of the reasons why it was looking at striking a lot of that in documentation standards, which is coming up in a few more sessions. I do believe that this treatment, the way that this is currently proposed here, treatment record is good because in the Model Practice Act and many other practice acts, when we review them, it required as part of the medical record, the initial evaluation, periodic reassessment or reevaluation, I think is how it's written in the Model Practice Act. Periodic reevaluation of documentation of each patient, and then, discharge patient's response to treatment. So it's generally very broadly defined in many other Practice Act rules and regs, and as written in the Model Practice Act, and they have commentary right there. If all of these nitty gritty things are removed, like we're discussing doing later in these upcoming sessions, then really what the board would be concerned about at that point when we're doing records would be, goes as this, is there an initial evaluation? Is there periodic reassessment? I'm not going to be actually. But anyways, you wouldn't have to define a daily note, a progress note, a reassessment, reevaluation, all of those things separately.
So we don't need it in definition if we're looking at the practical application and then get to just have, you need an evaluation in your chart, you need a progress note in your chart or a reassessment, and you need to have any other supportive documentation if you decide to do a discharge. So
The way that this is worded for treatment record, it also says it can be a checklist, flow sheet, narrative.
Good. I'm good with that. To be discussed at a
So-
further point.
For treatment, okay, can back up to treatment plan real quick. So we were talking about treatment plan and plan of care. So are we good with those to just leave them as is whenever I post it online for public comment? With no changes? And then same with treatment record. I'm hearing no changes, just post it like this?
The only thing that just came to mind is if you're discussing a treatment record and somebody is just reading this, treatment record can also be a reevaluation, and I can do just a narrative.
In this instance, it says treatment record is the documentation of a visit.
Yeah.
Somebody says, I want your treatment record. I'd give
We
it a
need to
5.
add as per standards for initial evaluation, progress notes, discharge summaries.
The written record of physical therapy is coming up, it's on the same page, I think we'll get to it. But that describes the initial evaluation. Treatment notes. So I believe that the treatment record, this context that we're looking at, was previously defined in the documentation standards as to mean, that's like the daily, that's like what they say the daily.
Do we need treatment record?
Yeah, do we need to combine treatment record and written?
Can you
record?
scratch it?
Chairman, I think there'll be robust public comment in regards to this. I anticipate that. Not to jump ahead, but my only comment would be, if we are going to include terms under the written record of physical therapy, if we're going to include initial evaluation, treatment note, progress note, reevaluation, and reassessment, if we're gonna include those terms under the written record of physical therapy, then those terms should be defined. There should be a definition. If we are going to remove all of those from the documentation standards, then we just need to have definitions of, the initial evaluation is defined by statute, but for treatment notes, progress notes, reevaluations, reassessments, those terms should be adequately defined under 123 so that there's no confusion as to what's required in the written record of physical therapy.
I agree with that. Probably contributors.
Can I just real quick, just so that everyone has it on the horizon, the food is ready, if and when y'all want to take a break. Sorry to interrupt.
We're trying to wait till
I
our
was just
second.
gonna point out that in the proposed revisions on the website, treatment record is really only showing up with regards to triangular. Or it will be if the rest of the documentation area goes as administrative. So it's just saying that documentation of the education and consent shall be maintained in the patient treatment record. That's the only place that I would see that.
So I guess the idea of combining written and treatment together would make more sense. To eliminate the confusion that treatment record is only for dry
Yeah.
needling.
Or we could change when we get to that point, you could change the language from treatment record to written record of physical therapy.
Yes.
But
If you have a definition of the written record of physical therapy,
You break it down.
and then now you have to have there's a statutory definition for initial evaluation.
Mhm.
We need a definition under 123 for treatment note. We need a definition under 123 for progress note, and a definition under 123 for reevaluation or reassessment. If we're not gonna make any further changes to the written record of physical therapy.
And we're happy with scratching patient care conference because it's not referenced anywhere.
Yeah.
And discharge documentation, not defining that.
Yes,
And we're scratching the treatment record altogether.
yes.
Very thorough.
And wait, you said scratch treatment record altogether?
We'll need a definition for treatment note.
Treatment,
Because that's included in the written record of physical therapy.
got you.
But
But,
treatment note, you'll be scratching treatment record.
okay, so recommend whenever we post it online,
Yep,
treatment
treatment
record
notes.
is removed. In the commentary under written record of physical therapy, we'll maybe say that we need to define those terms
Yeah.
and that they will be worked on and that,
And that section being called treatment notes, is that what you're saying?
If
Because a treatment note can be just a little.
if you want to scratch record from the definition of treatment record, just scratch record and substitute note. And if the board wants to consider that definition
Yes.
as
I
the
like that.
definition of treatment note,
Yeah,
then we just scratch record, put it as note, that takes care of treatment
We're
note.
gonna do that anyway.
Initial evaluation is defined by statute. We need to include a definition of what a progress note is.
Yeah.
If we want to port that from 341 and move that into definitions, we can port it over and put it into definitions.
so let me just throw one more thing in there. Documentation of a patient visit when a more detailed progress note or reassessment. Because those have different standard of than just a checklist, flow sheet narrative.
Michael, one, we're proposing to remove the term record from treatment record and then make that treatment note. And so that the treatment note will be the documentation of a patient visit when a more detailed progress note or reassessment is not necessary. A treatment note may be in the form of checklist, flow sheet, and narrative. Any objection?
okay,
Got skipped over.
Okay.
Knock both of them out.
Yeah, we did. More things.
Okay, well, yeah, so, and just to recap on written record of physical therapy, so we will take the words progress note and then the terms reevaluation or reassessment from 341 and put those defined in the definitions for the posted one for comment. That works? Just use the language that was in, okay, great. And then the rest of the changes y'all already said are good. So when feasible is proposed to be scratched. Currently, it's defined, it's still in the language of the law, but without defining it, it leaves it up to the professional judgment of the physical therapist to determine when things are feasible.
Lovely.
Okay, so that concludes the rule discussion. I do want to make a comment that some individuals were named during the discussion of public comment that was submitted. And so since we didn't directly read exactly the comments that were submitted and we summarized, they should not be reflected as the actual comments that were provided to us, as they might not be accurately summarized.
Thank you.
Fair enough.
Yeah, and so those shouldn't be a reflection of anybody's opinions or anything like that. And we will continue to take comment and move forward with everything that we will be receiving. Thank y'all for a great discussion.
Thanks, Charles.
Making a difference.
Oh, wait.
So look,
not
it's making a
breaking
difference.
lunch?
Question, yeah, we have a question, break for lunch, we go through a few more things and to have lunch with executive session. Oh, which of it? Maybe not cue these up.
Damn, I'll pull
We'll
the.
go fast.
Who
All
are
right,
you?
let's go.
Oh, to eat.
Next is gonna be,
Ben's ready.
is course sponsor continuing education application, fee waiver. And then Lee. gonna talk about it.
Thank you, Mr. Chairman. The CE committee received a request from the Health Education and Alliance of Louisiana. Her name is HEAL. HEAL is requesting a waiver of the course application fee for a seminar they're hosting in October. The CE committee referred this to the board because under Rule 193 E, the only sponsors who are eligible for waivers of course application fees are the American Physical Therapy Association, the Louisiana chapter of the American Physical Therapy Association, then programs in Louisiana accredited by the act. So there is no mechanism by which the CE committee could make a
And
determination.
again, those waivers are dependent upon the fact that their content met our
Yes,
criteria.
yes,
Yes.
there is preferential treatment only given to those three entities.
Yes.
HEAL is not included as one of those entities, and the CE committee does not have transparent guidance on how to make determinations about granting fee waivers. So our recommendation is that this waiver, I moved that this waiver this request for a waiver be denied based on HEAL not being represented in the three entities as established by 193, Rule 193.
Was that a personal motion or was that a motion of the committee?
That was the consensus from the committee.
Committee. I would second that motion.
Well, let me just throw this, just as a point of conversation. I'm not denying the fact that we have rules. Should we not include entities that are not sponsored, aka being supported by other entities and that are providing a course curriculum approved by the board that is free of charge to the attendees? I know it's not part of the rules, but, I think it would be.
The committee, in our discussions, the committee felt that there are a lot of course sponsors who would like to have the fees waived for board-approved courses and activities that are used for licensees towards their renewals. The current rules provide no guidance, on how the committee would make those determinations. And we feel that guidance should be transparent.
Yeah.
And it should be published so that course sponsors, could clearly understand the guidelines for which waivers will be granted. Presently, there are only 3 entities
Mhm.
that are in rule where we will waive the application fees for courses.
No, I understand that. What my point of discussion is should we not include entities that are not supported financially by or benefiting financially by other entity and also providing free of charge to all attendees the course as approved by the board?
I would support the board forming a task force to identify and to
Yeah.
establish transparent guidance
Good.
For the granting of waivers for entities outside of the entities that are established by Rule 193.
Sounds like a winner.
So
That motion?
I submitted a motion to that the course waiver request for the Health Education and Alliance of Louisiana be denied on the grounds that the organization is not an entity covered under Rule 193.
I would second that motion.
Is there any further discussion or public comment? All in favor?
Aye.
All opposed? Okay,
Thank you, Mr. Chairman.
thank you, Lee. Next, we'll have to, let's take a vote
Did-
on the,
Did I hear you talking about a motion to create a task force to look into other alternatives?
I can make that motion.
Okay,
Mr. Chairman, I move that the board create a task force to establish guidelines by which the board could grant waivers for entities other than the entities listed under Rule 193. And so that the board can have transparent guidance.
I'd second that motion.
any more discussion or public comment? All in favor?
Aye.
All opposed? Yeah, ayes have it. Move forward. Next, we need to take a vote on merchant method for SSC.
Yes, or, Betsy Reshore. Y'all had 3 proposals for you.
We open up for discussion.
So what do you feel like the last one that was done for us, that you kind of piggybacked off of the last one that you did internally? Prior to that, the program that had already performed that gave a presentation today. Feel like they were lacking in anything, like from your perspective, like something could have been done better? Offered by the proposal from the first gentleman that spoke.
No, I would say that, these are professionals who do this for a living. I think that we're in a win-win situation here. Because they do a wonderful job, and so SSA is very familiar with us. We were pleased with the delivery in the past. Never worked with Emergent Method, but they seem to be professionals as well. And then I believe Betsy Reshore does this quite a bit, just full time. So
Difference in
What it cost is,
pricing.
yeah,
Yeah, it's 3.
27,000. Like 27,000 for a person. I think it's
4.5. Yeah.
24 presidents, and 19,500.
I think if you look at, more than the pricing, or in addition to the pricing, you look at the sophistication of the work product that they're going to produce for us. I think is as important, if not more important than the price we pay, is what we're getting for our money.
Stupid question, but what's the point of strategic planning, or how does that work? What does that look like? And what is the ROI on that investment?
I mean, yeah, I mean, I've seen this done with other organizations. It gives you some goals. It gives you some short-term, medium-term, and long-term goals, and sets the overall, if, once you agree and adopt it, the direction, everything, that's supposed to spearhead your decision making almost with everything that you do. Then why
Okay, no, I understand the concept behind it.
Okay.
What is the practical application for?
Well, from what I heard is
Yeah.
it sets the standards for
It's
how
a work-
Charlotte operates, guides
Yeah.
our organization.
The strategic plan then becomes our work product. These are our plans, these are our goals, and then we prioritize those, and then we come up with a time frame of how to get what it is we need to get. Rules revision was part of that story, you know. Again, all of Charlotte's work product, and again, in the two organizations that I'm doing with Emergent Method at the time, it absolutely guides the principles of the work and the work product, and then gives you a tool to come back to measure. Did you do what was important? Did you do what the community said was important? Did you do what your stakeholders said was important? Did you get it done in a timely fashion? So it then gives you tools to come back and measure yourself. And then equally as important, it gives us a tool to measure Charlotte's performance by. So is the question, do we do one or not do one? I don't know that that's even an option for us. You know, we upgraded last year and we continued last year doing it internally because there were still things that were pertinent in the original plan from SSA that needed to be accomplished. And so we just updated our timeline.
Do we do it every 5 years or do we refresh it on like a rolling 5-year basis every year?
It's 5 or 3, Charlotte.
So this last one was a 3-year plan. Yeah, and it was, so before we had an organizational assessment to see sort of where we were and help with transition of leadership whenever my predecessor was retiring. We did an organizational refresh several years later where they sort of looked at where we were, what they had recommended doing, what had changed over time, and what they recommended moving forward. The last strategic plan was an internal process where we looked at, okay, we know our organization better than anybody. We know what our pillars are. We know where our weaknesses are. We know where we want to be operationally, things like that. And we did a proposal to the board, a workshop with the board, things like that, back to the board approved it. And that's what we've worked on in the last 3 years. So it was a 3-year plan. That's a long answer, but that was the first real strategic plan that we posted on our website for a 3-year period. We haven't done that
So
before.
these guys you pay 27,000 a work week for 3 years, is 1-year plan. How's that?
Give you the plan.
Yeah, that's the
Plan,
plan.
they don't-
That's the plan.
Yeah,
There's no follow-up after year 2 or anything?
So I'll say with SSA, I have worked with them. So after the organizational assessment, after everything, I've worked with them over the years. We meet frequently. Anita and I do. And it wouldn't necessarily be like, hey, this is what we're wondering about the strategic plan, but I keep her updated with the organization, things like that. It's more of a professional relationship. I haven't worked with Emergent Method. I don't know if that would be the same case with them, but I know that SSA has stayed very involved with us even after. It wasn't just like, here's your plan, good luck. And then we worked with them on other projects as well. We worked with them. We needed a third-party moderator for a legislative resolution to study if direct access would be safe or unsafe for patients with physical therapy. And we didn't want it to be any appearance of bias for us to moderate the discussion, to, not allow people to talk, things like that. So we brought them in to be a third-party moderator. Other state agencies have used them as well for their, the state, sometimes we have to do a self-evaluation report for the governor's office. And so I know some other organizations have hired them for that. So they do other things as well. And we just stayed in contact with them. So I don't know if Emergent Method stays in contact that way, but
They do.
yeah,
They
okay.
do.
It's not just a handover. It becomes a relationship
Okay.
and a partnership.
I mean, look, to your point, I think we all have our collective experiences and we think we know what's best. I think it's in the public's best interest that we even kick our own tires by having somebody help us develop their external expertise, our guidance, right? And so we can have a lot of input in that process through these interviews, but you need something from the outside to feed you a little objectivity and some knowledge that we don't have.
Yeah, I agree.
You don't know what you don't know?
How are we gonna vote on this? They both sound good.
Yeah, when I personally look at the work products and the depth, then to me, it comes between SSA and emergent method. I know firsthand what SSA did with us in the past, and now I know firsthand what I'm seeing emergent method doing. I kind of see emergent method as a broader vision and a broader tool, with a more national presence. You know, if I were to make a recommendation today, I probably would say emergent method, just because and I don't have a dog in the fight, and I don't, not getting paid by anybody to make an endorsement. I've just seen what they've done in the last 3 to 4 years with the organizations that I'm working with firsthand, and hands down, I'm completely satisfied and impressed.
Was, the last one that helped us, was that who determined and made that, with the investments that the board made? That kind of where that came from? Kind of
Was
just
that-
opening portfolios?
Was that at the last meeting?
No, I mean, like, I'm just asking, like, in general, like, the decisions that were made a while back, from an investments standpoint, and, stuff like that.
Like board designated funds?
Right, where we
Yeah.
made those buckets for different things and all that kind of put together. Were they the ones that came up with that? Or was that
No.
already existing before?
So, yeah, we've always sort of had investment policies for the board, but also, we've reviewed those over the years. The treasurer and I'll sit down and talk about them, throughout the years, but also the strategic plan is a way for us to say, okay, here's where we want to be in 3 years. And then this is what we think that we could accomplish in year one to get there. And then we look at the budget and say, well, what resources do we need? And what do we have in, like, do we need to redirect some resources? Do we need to use some? Do we need to designate some funds in that direction? And so a good example is, the real estate in the operational effectiveness portion of the current strategic plan. That was a big discussion of, hey, we're going to make an investment in this. And so that was one of those buckets. But yes, so it was not in the discussion whenever the strategic plan was approved to say, and this is how much it's going to cost to do each of these things. It came up more at board meetings where we'd say, okay, this is how much we think to accomplish this in this year we're going to need.
So the answer is that it wasn't the guidance of SSA or an outside contractor with strategic plan for us to determine how we handled our internal finances and board restricted funds.
I know that when I came on, looking at everything, I was surprised. I was like, man, you guys made some good decisions to be able to operate. I mean, we go to FSBBT and like all of them are funded by the government. Or right, they're doing all these sunset things to try to move funds around. They have very scarce people in their office because they're always losing funding, and we're existing on our own, completely independent. And so I know that things have been done well in the past, and I was surprised coming in how well things have been managed. And so I'd like to keep that operation going forward.
But is that a testament of how good of a job Charlotte is?
That's what I was asking. It
Or,
looked like it was in place prior to. They had made that decision.
and I know that there is an assessment, as Ode pointed out, that came out of the strategy. But having another plan that make Charlotte work any more efficiently, better.
I mean,
What's
That's
really
weird.
helpful, oh, I'm sorry.
I was wondering, like, SSC's been working with. everyone. Go to board, granted, you know them both, Ode, right? So you work with both of them.
Pardon?
You work with Emergent and with SSC.
Yes.
You got a feel for both for how they do their.
Yes.
Yeah, so I just know SSC a little bit, what we've seen. Did they do when we had all the board meeting, had to get together a year ago?
Yes.
That was SSC.
Yeah, so we had a like sort of board retreat day.
Yeah,
And we
that
went
was-
over, didn't update a review of where we were with the strategic plan. We had some guest speakers in, so SSA sort of moderates that date for us to help us with our discussion.
It's just from a practical standpoint, I'm trying to think about it, and obviously my business mind looks at the board differently than a business, but if I had plans or if I needed some assistance in planning an expansion of my business and having multiple different clinics, who do I need to speak to, Chamber of Commerce, blah, blah, blah. that I could see having somebody bring structure, but for a licensing board, do we need to meet with people? Are they guiding us in legislative affairs or interactions that we have with other boards or, beyond what you're already doing? So I'm trying to reconcile that in my head, from a return on investment, how is that impacting us as a board making decisions or as a board in the interaction with our licensees or in the protection of public or in your job? Now, you're better at assessing the support you need, but as far as the support I need you. And I need them.
They come and meet with us as a board, ask us questions about what's our goals and what's.
Oh, yes, that is
Yeah.
part of the
That'll be a
process.
few-
They'll interview us personally,
Oh, well,
one-on-one, do a gut check on you. They'll probably talk to, members of the governing body at the association, see how we work together, what's the
Yeah.
rub. They probably gonna talk to some licensees at random and say, okay, what's your feeling of the board? What's your interpretation? Are they approachable or are they the Gestapo or, just,
Yeah, the proposals, Jim, are very similar in
Yes.
terms of their structure. I agree with O'Day. I looked at the work product last night, of the different organizations. The work product of Emergent Method is very, very impressive in terms of what they've done. I looked at what they did for the School of Medicine, in New Orleans. That was very impressive. Emergent Method seems intentional in their desire to get feedback from stakeholders outside of this organization, including licensees, as you point, to see how the licensees view the board, and what they view the board's role is. So that seems intentional in their plan to get, to survey licensees. That was also mentioned, in SSA's proposal as well as a potential mechanism to get stakeholder feedback. So I think that's important, to get feedback. Any of these organizations need to get feedback from licensees, from the association, but not from the association from licensees, in the state, because not all the licensees are members.
and what we've learned politically that I think either organization or whoever gets chosen has to look at. What we think are stakeholders is exactly what you and I just discussed. It's us, it's the people we regulate, it's the association. But when you talk politically, the stakeholders are the chiros, the orthos, the hospital association, everybody who thinks they want to have say so in regulating what we do, those are stakeholders. Okay? So the world has changed. They used to say, have you met with your stakeholders? And have you met with the opposition? Now, the word stakeholders at the legislature means, have you talked to your opposition? So we need to be careful what we ask of them. Or do we want them to go talk to other boards and say, what do y'all think of the PT board? That may be helpful, get some feedback because they say, oh, they're either top notch or, we aspire to be them or they're a bunch of slugs. So I think one of the things that we need to do is guide them on who the stakeholders are.
Agree.
Yeah.
And the work product that SSA has produced in assisting in the strategic plan for this organization has been impressive. So I think it's from the standpoint, do you have the preference? Is there an organization that you're thinking that, okay, I want to work with this organization? Is there any feedback that you can give us in terms of how you would prioritize either organization?
No.
We're just showing up. You gotta follow, and you're the one working with them. We're here now, we're here this time, we're all day dealing with it, so if there's any way that you prefer, then it's put more on your plate or less on your plate. There's nothing, I guess it's just.
I was gonna say, if we're trying to, to Claude's point, if we're trying to continuously get an ROI out of this, can we look at either one of those two and saying whether or not the next product is going to be incrementally better than the prior product produced? Right. And so I've heard O'Day say that Emergent's product is more broad and maybe more, I don't know, I don't want to misquote you, but you know what I mean? Is it more encompassing than the plan that was given to us by SSM or the?
Yes, I think I'd use the word robust, in the
Okay.
fact that it's
So for the state,
more meat.
what I'm getting, instead of the stake of saying we're just gonna do a strategic plan every 3 years, we're gonna use it, get the word part, we're gonna implement it. I think we should also be looking to think, can we get an optimal product or a better product every time this proposal comes up to enhance what we pay for, what we try to implement.
So here's my question to you. What is ultimately your vision of what the board or where the board is going to be in 3 years from now, right? Because that's definitely going to be the supportive argument of going with somebody that's more global versus more focal, right? If you're looking at Louisiana becoming the staple of quality for other boards to basically mimic what we do here, then yes, the strategic planning is going to have ramifications of interactions with different boards and different contexts and different stakeholders, as O'Day described. So the logistics of it needs to be one that best assists your vision of how you think our board is going to impact not only us locally in Louisiana, but maybe beyond that. Because we've talked about doing an extra mile type conference using multiple different states coming together. If they have a plan for that, that's better than what you have or what we can come up with, then yes, there's definitely a return on that investment because we now use the platform that we're building and the directions that we are using and you guiding us through the process. Adam pointed out, we show up, we bring information to the table, you're in the application of, and you need to have the best support system if a plan needs to be put in action. If the plan that you're producing is of the same quality as what SSA is producing, then why do we need SSA?
Okay.
Right.
So the way that I'd like everyone to think about this is that the board determines what y'all want to see. Y'all know what y'all want. Y'all all came onto the board. Y'all all want something to happen while you're on the board in 3 years, in 6 years, whatever it is. Okay. And whenever different people come on the board, for us to have a plan in place, it's really helpful for the new people to come on board and we're like, hey, this is where we're going the next 3 years. We're not going to just change this every time somebody comes on the board. And during this period, we're going to plan it. We're going to bring your ideas too. Or do your ideas fit into where we're going here with this plan? Because you only have so much time and so many resources. But the board decides what has to be done. And then the staff, y'all have us to carry it out. And we can carry it out in, we can figure out how it can best be carried out. We can propose a budget for you guys to say, hey, we need these resources to carry it out, but y'all are really deciding the what. Okay. So I can help y'all. I can help give y'all a perspective on what's going on in the nation, internationally, with other boards. I can give y'all my opinions on it, but y'all have to decide on those things. Because y'all all are sort of nearing the end of y'all's first term, I think that this is going to be an amazing experience to have an outside group come in, ask all these questions. I sit on the executive board of the Compact, and we did a strategic plan. The staff was there and they helped us through it, but we were the ones who were deciding what we wanted to get done and what was important. And we were advising the staff and then we get updates from them. And so it's a really good opportunity, especially because our board meetings have become so efficient and we get through things generally really fast. It's an opportunity for us to really sit down, come up with a plan in this big meeting, and then go back and say, okay, now we know that the staff is going to carry out what we want to get done for the next 3 years.
Yeah.
Yeah.
Two point to that. Number one, you've mentioned that we're coming up to the end of our first term.
Yes.
So if I have the privilege of serving another 3 years, which I definitely want to be here for the next evolution of where the board is going and what we're doing, which is exciting. But you're going to be here a lot longer than we are,
Mhm.
right? So
Hopefully.
ultimately, the plan has to be one that involves you. I can come in and say, all right, my ultimate vision would be to have a national licensing board with delegates from each one of the 50 states, having Zoom meetings on the structure of the rules kind of thing, and having subcommittee that will deal with disciplinary actions. The same as you would have at my wife's school. You have a head of school, you have campus directors, and then you have supportive staff that comes underneath that. If that is my vision and I'm here for another year and then I get booted off, or if I'm here for another 4 years, but you're here for another 20.
But whenever y'all vote, it's not just your vision. It is,
Sure.
it is the collective vision of the group.
It's factored in. I wouldn't say you fly a weight what you think Charlotte needs versus what you think we need. It's just a factor that's baked into the cake.
So I don't know, how are we gonna?
So two options, we either can have a motion, somebody can make a motion and choose one and we vote, or everybody can write down on a piece of paper and slide it up who you think wins.
Let's do the latter.
Yeah,
That sounds fun.
or what? I'll read that.
You got some napkins?
Is that legal?
Is that?
And then with the vote will have to
Whichever
be,
turn.
right, it'll have to go.
Can I do it in sign language instead?
So what's the comment?
Is that legal?
Y'all have to vote on them, once
Let's say it out loud.
once that is read, then, y'all, someone's gonna have to move and second it and vote on it.
Well, then let's just vote.
We could just.
Yeah,
raise our
let's
hands.
just go. All right.
Roll call
Gotta
vote.
raise our hands.
We need a motion.
Need a motion to.
I'll make a motion.
Do we language the motion?
I would move that we engage Emergent Method to do our next 3-year strategic plan.
I'll second that.
Further discussions or comments? Public comment?
Roll call?
Your roll call?
Roll call vote, please.
O'Day Laverne,
Yes.
Michael Hildebrand,
Yes.
Adam York,
Yes.
Chloe Tremblay,
Yes.
Jen Gaines,
Yes.
Lee Riley.
Yes.
Wow, ayes have it.
Very good. John Snow.
Chairman, I move that
Give me more.
to get something to eat. Take it out.
Second, all in favor?
Aye. Just so you know,
I'm gonna take you, but next time I buy a truck, I'll take
Chairman of the Finance, we don't have a finance committee. But as treasurer, Charlotte said she wasn't buying lunch today. I said, I ain't coming. You gotta feed us.
Got food, you still got food.
It's easy.
Yes, it's in the kitchen.
Gotta feed us.
Yeah, I did.
Yeah, we have $8 not feeding us.
Maybe I was in the restroom. Thank you very much.
Yeah, we only brought
That's easy.
that's.
Easy.
Yeah.
When I bought my BMW, I ended up really putting a major.
We gotta take
Yeah.
valid three. Hey,
The general manager was like, all right, folks, what else do you need?
What else do I need to do to
I
get?
said, I want this, and that. And he's like, I can't do that. Well, I said, well, I'm walking out. So no, come back.
Mm.
I said, let's do this. I'm buying this BMW from home. How about if I buy the one right off your showroom floor, you do this, and that for me.
Jamie didn't say exactly what time.
Let me go look at the
So I'm
notes.
not sure what time.
So I got the X5 in competition
Go into executive session while we eat.
for
Uh,
$10,000
well,
less than MSRP.
Yeah, so we have a few more
Plus,
things to do
I ended up
and
with a
then.
$4,000
Especially
rebate
once we get to it, yeah.
Okay.
for military discount. Plus, I got a frequent flyer $1,000.
Yeah.
Plus,
And take the.
the fix of my windows. Plus, no, I break them down. That I love doing. I love doing.
Yeah.
everybody be on the way,
Right.
what could they do in
Yeah.
a month and put in.
Okay. So yeah, you wanna buy a truck?
Actually, I'll.
Okay.
I'll do that. Yeah. Trying to go to others, so. Not wrong. It's, good. That's the truth.
But she's on the screen, so she. So we can do it.
Yeah, I don't care. We were filming while I was sticking my nose, so might as well film me while I was eating.
Guess we just gotta be cautious, conscious of the banter.
For the members on Zoom, Jessica and others, we wanted to mute it while, we eat. And pause the video.
I'll go right next to, the microphone and
about the litigation, but I just wanted to say it's nice to meet all you guys,
Nice meeting you as well.
working with you.
And David.
So Morgan will stay with us until executive session.
Okay, next we're gonna talk about the military spouse and veteran license application fees. Cheryl, you gonna brief us on this?
Yes. So there's a federal law requirement that requires a different procedure for a military and their spouses to go through a licensing process that's different than everyone else. And we're following that. Just to update you all, we do have a military applicant right now. We're working on updating our online forms. And so we've been in communication with her to make sure that, she has the most simplified process we possibly can with the current, until we have our current application updated. And she has been great about all of this. So we are working on updating our application, but in the process, we reviewed Texas's procedures coming out of Leadership Issues Forum. I was talking to them, and one of the things that we saw on their website is that they have an application fee waived for anyone who is military, their spouse, or who's a veteran, and they have certain ways that you can show that. And I thought that that was a really nice gesture from Texas, and so I just wanted to bring that up to you guys for consideration, if you would like to waive the fee for those individuals. We do already, and we waive it for compact privileges, and we do ask if you're military already on our app.
Double. Yes.
We need to take that vote for that, or just.
Do we have a motion?
Yeah.
I move,
Ode?
I'll second.
I move what she said.
Flynn?
Which is
Okay.
Both second. Any
that
discussion?
procedurally
Mhm.
appropriate?
Discussion, public comment? All in favor?
Would that include relicensing or just initial license?
The application fee would be waived. Oh, you mean renewal?
Yes, for renewal.
So
Would that just include just the initial application for licensure, or would it also include renewal?
I don't know that we ask if you're military at renewal, so I'd have to check on our system to see. But if you all would desire to waive it for renewal, then we can look into.
Courtesy would be in this instance, when they get shipped around and moved around, if they show up in our state, because they're serving our country and they show up, then we should waive that, no matter, if they're gonna live somewhere. So when it's renewal time, they probably have to pay a renewal fee.
Okay.
But the fact that the burden to them is that every time they get moved around, they have to pay another application fee, and it's not their fault that they moved. So I think it would be a great idea.
Application.
We do waive our compact renewal fee,
Or.
military. We waive the initial and the subsequent. Just, so,
How many people are we talking about here?
it's not that. You want to say for initial?
Yeah.
Okay, so we have a motion from Ode, a second from Claude.
More discussion? Public comment? All in favor?
Uh,
All opposed? The ayes have it.
Thank you, Philip.
Okay, next, we're gonna bypass the consent form. The next item is the appointment of a member to the investigative committee. Bill Page, former member of the advisory committee and of the board, is running for executive board of the APTA, which creates conflict with him serving on the investigative committee. So we want to take a moment to acknowledge and appreciate his years of service. Feels great.
Yep.
And dedication to the board. And the current member of the investigative committee is one board member Adam Short, two advisory members, Marie and Chris. And we would like to nominate Ben Gaines.
Coffee.
To serve on the investigative committee. To provide a public member perspective during the investigative process.
Mr. Chairman, I move to nominate Ben. Let's get him in.
You have that much time there, man?
Second. I'll second.
Discussion?
One of the points to support that, besides the fact that Ben's a great guy, okay? I think it's real important that our public member serves on the investigation committee, Because sometimes as a professional, we have trouble separating ourselves from the people that we are investigating. They're one of us, we're one of them, okay? And that's not our role. Our role is not to rehabilitate people. Our role is not to be nice to people. They broke the law, we should enforce the law. What I've seen in the past, since we've had public members on the board, that they'll look at something and say, oh, hell no. You know, and we're sitting over here, you know, well, what do you, no, that's not acceptable. So we really, more importantly than us interpreting the Practice Act, we need to know what the public member thinks is acceptable behavior or not. Okay? And a lot of times that may be absolutely different than what we think of, because we could put ourselves in that position at any given point in time as a licensee. So I would thoroughly endorse, if might always have our public member serve on this committee.
Yeah, I think you could do it. I think that if I have the time to do it, then not saying that I'm the only one that has stuff going on, but it's doable. A lot of it's through Zoom, and we have some in person for the investigation, stuff like that. And, you know, it's planned out well ahead of time.
Yeah.
I think it, Bill was, you know, super awesome, and me coming on, I really had no idea what was going on. But I'd sit through this and that, but as the time went on, I became more of a, you know, more role on it and having, you know, an actual presence on there. So, I'm super appreciative of Bill for all that he did, and, the fact that he stayed on long enough for me to really figure out what's going on. The rest of the team on there, super good too. Everybody's good, and the process is done with, the attorneys and Charlotte and everybody. Everything's organized for us. It's, I don't know, I've enjoyed the process thus far. So, I hope that you would agree to it.
According to O'Day, it's pretty easy. Hell no.
So Lee moved and Adam seconded.
Ben, you up for it?
I'm up for it.
All right.
Thank you, Ben. Any further discussion?
Thank you,
Public
Ben.
comment?
This is the investigative committee as defined by one board member, the executive director, and one attorney. That,
You talking about the definition in definitions? Like in 123?
so, yes, and I'll say it's confusing to me because the investigative committee, I believe I'm using the right word, I think has previously been stated as one board member, executive director, and council. But y'all just called out that so we're moving to nominate Ben to replace Phil. Adam is on it, and then 2 advisory members. But previously it was stated that all investigations go through one board member. I mean, I think I may be confused on what your actual process is currently.
But is your question about the appointment or the composition? Because the item on the agenda is the thing.
But if all, as previously has been stated, if all complaints are going through one board member, and that one board member is then, no offense, I respect every contribution of the
No, that's.
made. No, I mean, and both of you, there's no, but he's an attorney. And so from a public perspective, we would be having every complaint go, not being heard by any PT, but only being heard by an attorney, executive director, and another board counsel.
In the rules. I would not say that's an accurate characterization of the committee composition.
Is the concern that there's not a PT involved with the investigation? There's 2 PTs involved with every investigation, and that's, they're on the advisory committee. So we had Marie Morgan, and she's with LSU Shreveport, and she's been an educator for decades. And then we have Chris Franks, who's from Lake Charles, and he works in the hospital.
I think I was under the assumption of maybe an old model that we're using. But I
Yes.
thought every investigate.
It has
every
changed.
Complaint was going to Phil.
No,
No,
we changed the model,
Okay.
I believe in 2024-ish. I have to go back and look exactly, but we changed the model of the investigative committee to be a standing committee. And so we used to switch the board member for each investigation, and now we have a standing committee. And
Because
it's,
with every investigation, it's two PTs, Adam now will be, then if this motion passes, board counsel and yourself.
yes, and,
Okay.
and investigator.
Yes.
Yeah, and the definition says typically.
Where is that definition, Charlotte? I'm sorry.
It's in definitions, it's investigative committee.
Okay. it's in
And it
definition.
says the panel designated by the board policy to investigate complaints and to conduct informal conferences in disciplinary matters typically composed of one or more board members, the executive director, investigator, and legal.
Is that further defined in policy of who is actually involved in investigations?
I think that it was in a board motion, actually. So we probably need to update that definition. Good point.
Any further discussion or public comment? All in favor of Ben?
Aye.
All opposed?
Congratulations.
Ben,
That's where you give your
congratulations.
acceptance speech then. Have one prepared.
Didn't even know this was coming.
When we get our gifts.
Rascals.
Thank you.
Yeah.
Okay, now this is our final item of new business, establishment of a finance committee. O'Day is currently serving as secretary treasurer and his appointment expired unfortunately in July 2026. So I recommend that we appoint a member of the board and or members of the advisory committee to serve as the finance committee of the board and allow O'Day to continue serving as secretary treasurer until elections in January 2027. Or until the governor appoints replacement for his board position, whichever occurs first. Any questions or discussion regarding the proposed finance committee?
Question. So currently, we don't have a finance committee. We have secretary treasurer.
Right.
What we've attempted to do is to work as an executive committee, as the chair and the secretary treasurer in things such as reviewing Charlotte
Right.
and her job and her performance to make sure that it wasn't just one person doing it and then she had to kiss up to that one person, make sure that one person liked her. So we tried to make that a committee to do that. We currently don't have a finance committee. It's just the treasurer. So are we looking to, and I'm very willing to have the treasurer be replaced and I'll work with them for the remainder of my term, however long that I'm here to get that person up to speed. Or are you wanting to create a finance committee, which would put more than one person on there and we're kind of short of people to begin with, which is kind of why we've never done a finance committee. But I'm not,
Right.
you know. Are you just looking for somebody to train and step up and take my place, or are we looking to create a committee? That would be my question of the question.
I think as long as you're here, you should be, to me, you should be the treasurer with us until January 2027 or
Yeah.
until the governor makes that announcement.
Yeah.
Unless somebody else,
What would be the scope of work for the finance committee?
So
because we haven't had that before.
I think that, if anyone on the, who's currently serving on the board is interested in serving as treasurer, whenever elections come up in January, then this would be a good overlap period for the individual to, have overlap with O'Day, who served as a treasurer for a while now. And, also if O'Day, if the governor appointed somebody in O'Day's position, then that individual, we wouldn't have a period with no sort of like treasurer.
Right.
You know, I mean, we wouldn't have a treasurer until the next board meeting when, but there would be somebody on the board who is involved with the finance committee.
Yeah,
in that
I
event.
don't think you need a finance committee, but I think you need somebody to step up like now. I would be very happy to have somebody step up that wants to be the treasurer and then we have a transition period. But I don't think that it's a job that needs a committee.
Right.
Okay.
I think it'd be a waste of another board position having a committee.
Right. So,
Who wants to be the next treasurer? It's a much better job than being the chair.
Y'all already put that
Ben and I tired.
Somebody say, nominate Ben.
What a day.
Ben's having a good day.
Or no, but elections would be in January, correct?
Yes.
And we have no way of knowing when the governor will appoint.
You sit
Could be
until
a
the
year.
end of your term and that defined date is the end of your term, or you sit?
No, here you serve until your replacement shows up, but no more, I think I've been told no more than 2 senatorial appointment scheduled, so 2 legislative sessions,
Yeah.
2 legislative sessions. So Phil served almost a whole nother year before his replacement was appointed. Yeah, I mean, he served quite some time while we were waiting. You know,
You can serve up to 2 Senate sessions.
you can serve up to 2 senatorial sessions, yeah.
Do we need, we only need somebody right now. We got till January for.
Theoretically, he may appoint somebody next month, okay, and then I'm out, because my term is over in, when? It was over in July?
Yes.
Yeah. So theoretically, my term has expired and I could be replaced any day now.
Mr. Chairman, if it is the will of the board, I'd be happy to serve as the treasurer.
We're just waiting you out, Lee. Waiting you out.
You want to be the treasurer? Is that,
Thank you,
If
Lee.
that is the decision of the board, yes, I'd be happy to serve.
I would
Thank you, Lee.
be very comfortable with that.
Y'all could be a committee right now.
Thank you, Lee. I appreciate your step.
So, yeah.
Yeah, so I think in the meantime, we just start working together and do that. I wouldn't suggest that we start a new committee.
Right.
You know, then that
Y'all
just,
are the committee.
then that burdens,
Committee.
then now that makes 2 people that need to get together. Then you have to publicly have a meeting, whereas, you know, Charlotte talks to me about anything she needs financially and yeah, I give her advice and she just preps me on what she's doing.
Right.
I don't think it needs a committee.
Thank you, Dave.
No,
We're all
my
at
pleasure.
your service.
My pleasure. Been good.
Wish you stay on. Thank you,
But
Lee. Okay, now, the board, now we move into executive session.
Is there an issue? I have a question for the attorney. I'm sorry. Do we need to vote on the election or can we only elect in certain months?
It says the election shall be held in January.
Uh-huh.
Okay. But it also says in January, you shall elect the president and now that our chairman, now that a chairman is appointed by the governor, then that negates our January election for the chair.
Does say. Shall.
So
But not at council, but I would think with the fact that my term is up. We do know that there's, and I'm the representative from the association, they have submitted their letter with multiple recommendations to the board and commissioner's office or the governor's office. So, you know, it could happen any day. Could happen in 18 months, but sometime between now and an election. And I'll for sure come January, if I'm still here, I'm not gonna run for treasurer knowing that my term is expired. And we could legally have an election, but in the meantime, you know, I think we need to prepare for the fact that we may have a vacancy in the position.
Yeah, handle.
So, you know,
So you'll continue serving as treasurer, working with Lee, and if you become vacant, then we will fill the vacancy.
Yes.
Okay.
Move Leo's.
Okay, so you're comfortable with
Yes.
that? Lee? So we won't establish a finance committee and we won't change treasurer right now. Okay.
Mr. Chairman, I move that we enter into executive session in accordance with Louisiana Revised Statute 4217A1, 2, 4, to discuss the matters of the consent order.
And
Second that motion?
Any discussion? Public comment? All in favor?
Aye.
All opposed?
Clear the room and clear the.
To discuss the consent order, 206I09 and impending litigation on the 15th Judicial District, docket number C 206-43361.
We'll have Elise and Charlotte in the executive session.
All right,
Thank you.
nice to meet you guys.
Okay, nice to meet you.
Where the people?
What? We may have lost a few, but we do still have some.
Excuse me.
God bless you.
Thank you.
You remember any of the staff in the area?
You might want to remind her.
Miss Pam and her sister, Miss Pam used to tell me all the time, bless you. I miss these 3 times in a row. Bless you. Save you. Go to hell.
Go to hell, bless you, baby, go to hell, stop
I've never heard that. That's
God
funny.
bless you. God save you. Go to hell.
Yeah, moving though.
Kids are actually by themselves.
I guess because at that point, you're making other people sick
My husband had a.
or just be gone? Like, what's the meaning of
I
that?
have no clue.
Is that a cultural thing? Where's that come from?
It's Lauraville.
Is Lauraville?
Yeah, I guess.
Well, I forget, that's where your wife's from? Florida?
No, Iberia.
Yeah.
Actually, she was born on the Air Force Base in Georgia.
And where?
On Warren Robin Air Force Base.
Okay.
Her dad was in the Air Force.
And the bigger in here.
That's right. They live right by.
Like that's.
You know where all this mythical God bless you comes
Just
from?
for a while.
No.
The belief that
I'm
when
gonna
you
try to combine
sneeze,
it.
the evil spirit comes out of you, so bless you before they come back in, then.
Or that your heart stops beating when you sneeze.
Yeah, that's,
So they bless you that hope you come back.
yes, that's it.
Is it the same in different languages? Is the meaning the same? Yeah, like what is Gesundheit? Literally.
One, two,
See, I don't even know that.
everyone's here.
But there's something to find out.
Yeah.
You coming?
What is the proper response to
Real quick, I got to validate your stuff
Where do you do that?
upstairs.
downstairs on the 23rd? I can take y'all there.
Oh, we're on 24 now?
We're on 24
Okay,
now.
sorry, 23rd.
I'll walk you down.
You get out, you take a right. There's a
Yes,
lady-
go upstairs to the roof.
Wrong spot.
For some reason I thought it was the other way
Goes
around.
down there. Me too.
Yeah,
Listen, Michael.
No, he's right there behind that.
Wait, yeah, we're waiting
Oh,
for
we should exit.
our members of the public.
I think everyone from the public is here.
What about those?
Well, Angela just walked out.
Man to the left,
No, oh, I have no idea.
Mr. Chairman, I move that we exit executive session.
Second. There's-
second that motion.
Public comment, discussion. All in favor?
Aye.
All opposed? Okay.
Gesundheit means health,
Figure.
good health, or cheaper health.
Okay, we'll now discuss, consider any action appropriate on the matters discussed in executive session. We're going to review the consent order 2026-I-.
Mr. Chairman, I move that in the matter of Alexander Wiggins, license number A1108, and the consent order number 2026I009, that we accept the consent order.
I'll second. Any further discussion or public comment? All in favor?
Aye.
All opposed? Regarding pending litigation matter, is there any action to board? Hearing no motion, we'll take no action at this matter at this time. Is there any further business to come before the board?
Move adjourned.
Meeting is adjourned. Thank y'all. Thank everybody.
By your birthday.
Thank you for doing business.
Thank you.
At least, nice chat. I always appreciate you.
Y'all holler anytime you're in town.
Oh, I didn't bring my credit back up before.
Yeah.
You gonna
Well,
have to.
Maybe she'll give you a sticker.
Just go down, grab it, and then come back up to 23. I'll meet you at 23.
Hi, guys.
All right, I'm about to crown a roll too.
Yeah, but.